If it pleases the court, at some point, if I
All right, everyone, it is now 9 o'clock. This is the state all-purpose calendar in the state court of Fulton County, Georgia. Today is June 30th of 2022, and I am Judge Melanie Williams. Today at this calendar, we'll handle a variety of matters, including arraigning cases, taking pleas, and handling other matters as necessary. We will also handle the competency calendar and as we proceed through all at once. I don't have any objection to the jail bringing us people who may appear on that calendar. All participants, this particular proceeding is being broadcast over the internet as a live stream. That means any member of the public can log on and watch this just as if we were in person. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You have a right to an attorney at this proceeding as well today. Before we begin, are there any attorneys who need the opportunity to speak with their clients? Has every attorney had the opportunity to speak with their client before we proceed?
Your Honor, there were a couple of people that were not, one person didn't come out. I don't know if he was sick. And one person, they told me that the floor deputy was unavailable to bring him out. The latter person's name is Ricky Williams. So if the jail could have Ricky Williams telephone me on my cell phone, I'll duck out over here.
Okay. And you don't have access to the chat, Mr. McLean, do you? To put your phone number into the chat unless you did it on your phone.
Well, if I could zoom in. Let me.
Okay, if you zoom in and perhaps put your phone number in the chat. At the jail, could Mr. Williams please give Mr. McLean a call? And can we go first to a position that Mr. Finling has while that's taking place? Who do I have in the courtroom to?
Your Honor, Ricky Williams is on 3 North. That's a mental health floor. So there's an officer that's roving the floors. So it's going to be some time before we get to him.
Okay.
That's probably why he didn't come out. He's on that mental health floor.
Okay,
All right.
all right.
And
In front of you, I got position number 29, Mr. Corey Simon.
All right.
Okay, that's mine.
And it's a negotiated plea. Is that still the announcement?
It is, Your Honor.
Okay. All right, Mr. Simon. Is it Simon?
Yes, ma'am.
All right, good morning, Mr. Simon. Your case number is 22 CR 003652G. And what you're charged with, one count of obtaining unlawful entry into MARTA and criminal trespass with the offense date of June the 9th of 2022. Do you understand those constitutional rights I just explained to you?
Yes, ma'am.
All right. As it is a negotiated plea, what's going to happen first is I'm going to hear from the state regarding their recommendation. Then I'm going to hear from the attorney. And if you wish to go forward with the state's plea offer today, I'm going to ask you a series of questions to make sure that you're voluntarily taking this plea. You understand that? You understand that, Mr. Simon? Oh, did the jail freeze? Okay. Mrs. Simon, did you understand what I just explained?
Yes, ma'am.
Okay, thank you. Whose
Your Honor,
case is this for the
Can you
state?
please tell me what position this is?
We're on position 29.
On position 29. Okay, and that would be my case, Your Honor. Give me one moment. The offer on this case, Your Honor, was time served 32 days and stay away from all MARTA locations through February 11, 2023.
All
Nothing
right,
further from the
so
state.
no additional time to be served at the Fulton County Jail?
That is correct.
And that is our understanding as well. And we stipulate to all matters that need stipulating.
All right, thank you, Mr. McLean. I appreciate that. Mr. Simon, do you understand that, please? So if you take a plea today, the time that you served in the Fulton County Jail will essentially close out your case. However, you cannot return to MARTA until February the 11th of 2023. And if you do, you land right back where you are. Do you understand that?
Yes, ma'am.
And you like to take this plea today?
Yes, ma'am.
All right, I'm gonna ask you a few questions to make sure the plea is voluntary, all right? Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force or coerce you into taking this plea today?
No, ma'am.
Do you understand that by taking this plea, you're waiving your right to challenge the evidence in a court of law and the right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you're prepared to waive all the rights you would have had if you had a court date?
Yes, ma'am.
And again, you understand the requirements of the sentence as I just explained.
Yes, ma'am.
As to the charges previously listed, Mr. Simon, how do you plead?
Guilty.
I accept your guilty plea at this time. That if there's nothing further from either the state or the defense, that should conclude Mr. Simon's case today.
Okay, thank you.
Nothing further.
All right, thank you. Best of luck to you, sir.
Thank you.
Next, we have position number one, Mr. Allen, Barry Allen.
All right. All right, Mr. Allen, your case number is 22 CR 003855C, in which you're charged with battery in a public transit vehicle station for the offense date of June the 8th of 2022. Do you understand the constitutional rights I explained?
Yes, ma'am.
All right, and I have that this is a negotiated plea as well.
That's correct.
That is correct, Your Honor. Good morning. How are you?
Good morning, good to see you. All right, Mr. Walker, what is the state's plea recommendation?
The state's recommendation is 12 months to serve 10 days, credit for time served 10 days, balance probated with the conditions of an 8-week anger management, a stay away from all martyr locations and no further contact with the victim. Please bear with me. I will have to spell that name. 1 second. So the victim's first name is Mafi, spelled M-A-F-I. Last name is spelled S-H-A-H-R-O-K-H. Nothing further from the state.
All right. And Mr. Finley, is that your understanding of the plea offer?
Morning, Judge. Yes, that is our understanding of the offer, of which we do agree. Would just ask, Judge, that once Mr. Allen does complete that anger management class, that he could be on non-reporting, and also if the probation fees could be waived as finances are an issue in his life.
No objection from the state, Your Honor.
All right, I will waive 3 months of fees to give him time to take that class. All right.
Understood. Thank you.
All right, Mr. Allen, as you just see me do, I'm going to ask you a series of questions to make sure that you're voluntarily taking a plea today. All right.
Yes, ma'am.
All right, and you understand the requirements that just explained by the state, that essentially the time, you will not have to serve additional time at the Fulton County Jail, but you will have to attend the 8-week anchor management class. Mr. Walker, will you put that stay away address onto the record?
It was a stay away from all martyr locations, Your
Oh,
Honor.
all MARTA, all right. So, Mr. Allen, you cannot return to any MARTA in its entirety as part of taking this plea today, and you can't have any further contact with that victim. Do you still want to take that plea at this time?
Yes, ma'am.
All right. Are you under the influence of any drugs or alcohol?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force or coerce you into taking a plea today?
No, ma'am.
And do you understand that by taking this plea, you're waiving your right to go to court later? Essentially, you will not have another court date. You understand that?
Yes, ma'am.
And you won't be able to present any defenses you may have had to these charges or make the state prove these charges against you beyond a reasonable doubt.
Yes, ma'am.
And you do understand the requirements I just explained?
Yes, ma'am.
All right, as to the charges I previously listed, Mr. Allen, how do you plead?
Guilty.
I accept your guilty plea. All right, best of luck to you, Mr. Allen. That will conclude your case. Is there anything further from either the state or the defense at this time?
No, Your Honor.
Nothing
All
further.
right,
Thank you.
all right.
Next, position number four, Mr. Bolton, position number 4.
All right, good afternoon, Mr. Bolton. Your case number is 22 CR 003854J, in which you're charged with several charges. Let me get them all straight. You were driving in a circular or zigzag course, laying drags. You had an expired license. You engaged in reckless driving, and you were also charged with driving or fleeing, attempting to elude the police officer, each with the offense date of February the 18th of 2020. Do you understand your constitutional rights? I need you to answer, Mr. Bolton. Do you understand your rights?
I say yes, ma'am.
Oh, thank you. It may be that the Zoom went out and I just couldn't hear you. I appreciate that. All right. At this time, I've heard that this is a non-negotiated plea. So what that means, Mr. Bolton, is I'm gonna hear.
Your
from
Honor, I'm sorry, not to cut you off, but it has changed to a negotiated plea.
Oh,
I'm sorry to
wonderful.
interject, however.
No, thank you for interjecting. That's wonderful news. Basically, what's gonna happen, Mr. Bolton, is I'm gonna hear from the state and you'll have the opportunity to tell me if you still want to take this plea today, all right?
Okay.
All right, Mr. Walker, what is the state's recommendation for the several charges as listed?
Yes, Your Honor. To count one, we will be merging count one into count three, which is the reckless driving. Count two is going to be 12 months served, 30 days. Credit for time served, 15 days, ballots probated with the condition of 50 hours of community service to count two. Count three, 12 months to serve, 30 days. Credit for time served, 15 days, balance probated with an additional 50 hours of community service. And count four, similarly, 12 months to serve, 30 days. Credit for time served, 15 days, balance probated with an additional 50 hours of community service. So essentially, the defendant will be on probation and he will have 150 hours of community service to complete. There is no objection to early termination upon completion.
All right, and there's no fines, I'm assuming.
The fines were converted to the community service, Your Honor.
All right, was that the sticking point earlier between the two parties? All right.
Yes.
And you all have agreed to community service. So, Mr. Bolton, you understand that it appears to me that you will not serve any additional time at the Fulton County Jail, assuming you get the 2-for-1 credit, but you will have to complete 150 hours of community service and you'll be on probation until you do so. If you went ahead and completed that early, your probation would terminate. Based upon that, Mr. Bolton, do you wish to take this plea today?
Yes, ma'am.
Okay, but I'm gonna come back to you. I'm gonna ask you a series of questions. Mr. Finley, was that your understanding of the offer?
That's correct, Judge. That was our understanding with the community service, and obviously was going to ask about the early termination once he does complete that.
All right, and do you stipulate to the factual basis, identity, and venue?
I do, Judge.
All right, Mr. Bolton, I'm gonna go ahead and ask you that series of questions. Are you ready? I need you to respond to each question. Are you under the influence of any drugs or alcohol at this time? Are they frozen? I think we froze for a moment there at courtroom 2. Are you under the influence? I'm sorry?
We did. We froze for a couple of seconds.
All right. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force or coerce you into taking this plea today?
No, ma'am.
Do you understand that by taking this plea, you're waiving your right to challenge the evidence later in a court of law?
Yes, ma'am.
And you're prepared to waive all your rights?
Yes, ma'am.
And you understand the requirements of the sentence as I just explained to you?
Yes, ma'am.
And you wish to go forward with the plea today?
Yes, ma'am.
As to the charges previously listed, Mr. Bolton, how do you plead? I accept your guilty plea. If there's nothing further from the state of defense, that will conclude Mr. Bolton's case.
Next,
Mr. Bolton, sir.
Next, we have position number 6, Mr. Brewster.
All right. All right, good morning, Mr. Brewster. Your case number is 22 CR 0038991D, in which you're charged with making terroristic threats with the offense date of June the 17th of 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right. The announcement that I have is that this is negotiated as well. Mr. Walker, what is the state's recommendation? Mr. Walker still there? Is Mr. Walker frozen? Give him a few moments.
ASG Walker did text and say that he lost connection. He's trying to reconnect.
All right, we'll give him a few moments.
Okay.
If it takes too long, we'll try to go to another position.
Okay.
And may I ask, who is that position at 7 South? Who is that at 7 South?
Position number 17, Mr. Gomez.
Okay, I believe that's probably Mr. Walker's position as well.
Mm.
So, oh, there you are, Mr. Walker. You're muted, Mr. Walker.
And also, I'm gonna need to talk to Mr. Gomez before his position's called.
All right, this is your position as well, Miss. I was gonna see if you could do it now, but position 6 is yours, Mr. Finley, I'm assuming so. All right, so as soon as we do this, hopefully, we can get Mr. Finley into a breakout with Mr. Gomez. All right, Mr. Walker, we'll go back to Mr. Brewster. Will you put the state's recommendation onto the record, please?
Yes, I'm so sorry. My power went out and I'm on my phone, so just bear with me. I'm trying
All
to
right.
get everything back up and running. But the state's recommendation is 12 months to serve, 7 days, credit for time served, 7 days, balance probated with the conditions of a mental health evaluation, any necessary treatment, an 8-week anger management, and a stay away from the incident location, which I will provide, and no further contact with the victim. 1 second. That stay away location is 4874 Old National Highway. And the victim's name in this case is Mr. Taboada, I believe.
Okay. Is the address on Old National Highway a home or a business?
I believe it's a business, Your Honor.
Can I have the factual basis here very briefly, Ms. Walker? I understand this is negotiated. I just want to understand.
Okay, so to answer your question, it's a hotel and there was some type of dispute with the clerk, the defendant, and the defendant's wife. At that time, the defendant became angry with the clerk and did assault the clerk.
Okay.
So this was an incident at a hotel on Old National Highway.
All right. And the clerk is the victim here.
That is
All right.
correct.
All right, understood. Mr. Finley, was that your understanding of the plea offer?
Yes, Judge, that was our understanding of the plea offer. We're just going to ask that once he does complete that mental health evaluation and the 8-week anger management, if the balance of his probation could be terminated, but I understand if you're not inclined, non-reporting.
I'm inclined to do the non-reporting, and I'll waive the 3 months of fees to give him time to take that course as well. All right.
Understood. Thank you.
All right. Let's see. I'm going to ask you the questions as well, Mr. Brewster. All right. All right. Are you first, do you understand the requirements of that? And do you wish to take this plea today? You wouldn't have any additional time to serve at the Fulton County Jail, but you are going to have to undergo an evaluation and take an 8-week course. And you also cannot go back to that hotel.
Yes, ma'am, I understand.
And you want to take the plea?
Yes, ma'am.
All right. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Has anyone forced or coerced you into taking this plea today?
No, ma'am.
And do you understand that by taking this plea, you're waiving your right to go to court at a later date and present any defenses you may have had?
Yes, ma'am.
And you're prepared to waive all the rights you would have had associated with the court date?
Yes, ma'am.
And you understand the requirements of the sentence as well.
Yes, ma'am.
All right, as to the charge of terroristic threats, how do you plead?
I plead guilty.
I accept your guilty plea at this time. And if there's nothing further from either the state or the defense, we can go to the next position. Best of luck to you, Mr. Brewster.
Thank you.
Can Mr. Finley be put in a breakout with 7 South so he can interview his client? And we perhaps go to position that belongs to Mr. McLean?
I got position number 19, Mr. Kimber.
That is a bond reduction request.
Bond hearing only, has this case been arraigned?
I did not, I was actually only at the jail yesterday, did not get a chance to go by Odyssey and check that.
Okay,
Does the Odyssey seem to indicate that he may have been?
previously, position 19. If not, I'll log into Odyssey and get.
To save time, Your Honor, I can waive formal reading and make sure that somebody in our office files motions if they have not already been.
Okay, so, all right, since in light of the formal waiver, we'll jump right into the bond hearing. If you could get that filed today, Mr. McLean, we'd appreciate that, all right? Mr. Kimber, your case is 22 CR 00567H, and what you're charged with giving false information to a law enforcement officer and carrying a concealed weapon with the offense date of April the 4th of 2021. Do you understand your constitutional rights?
Yes, ma'am.
All right, at this time, we're gonna hold a bond hearing. Whose case is this for the state?
That
Oh,
would be me, Judge Williams.
thank you. What is your recommendation, Ms. Practice?
The recommendation in this case is for the bond to remain the same. He has a 4K surety bond on the concealed weapons charge and a $2,000 surety on the giving false information to equal $6,000 surety. Your Honor, the officers responded to an armed person call at 1174 Euclid Avenue. When they arrived, they observed a male in a yellow sweatshirt, which matched the caller's description. The officer then approached and asked the defendant what his name was. And he said his name was Mazazi Momoshki. And he gave the correct date of birth. Officers later discovered that he had given a false name. He admitted to having a concealed weapon on him, but said he could not provide the permit because his license and wallet had just been stolen. And so in speaking to the caller, who's also the victim in this case, Mr. John Ballantine, John common spelling, Ballantine is spelled V as in Victor, A-L-I, N as in Nancy, T as in Tom, I, N as in Nancy, E as in Edward. The officers learned that the defendant was basically had verbally accosted him and threatened to shoot him and calling him the B word and yelling obscenities at him. So 2 witnesses did see this incident occur. One saw him just putting the gun in the waist. They didn't see him point it, but the other witness did see him actually point the gun at the Mr. Valentine. Officers ran his name for a concealed permit later and also found out that he does not have a permit despite the fact that he said that he had one. And so the state's recommendation, really, Your Honor, based on the criminal history, he's got 9 cycles, but 2017 terroristic threats, 2018 simple battery, 2019 he's got a battery, family violence, and giving false information, which he was on probation at that time for 4 years and 6 months. He's got a probation violation in 2019, and then he's got criminal trespass, 2 counts of criminal trespass, and 2 probation violations in 2021. So based on his really probable risk of reoffense, and the already being on probation, having somewhat of a violent history and similar offenses in the past, and because probation does little to deter him, the state's recommendation is really that the bond stay where it is.
All right, thank you. Mr. McLean?
Yeah, the practical argument for him for a bond reduction amounts to this. With the current 6,000 total, I believe it is, if I'm correct. He would be using family to make his bond anyway. He is in a communication with his mother. I've left his mother a message. It would be his family making the bond at any rate, and he would be pledging to the court to keep up with this court date. He and I had a discussion in the jail yesterday about how you can't miss your court date if you every week and a half to 2 weeks come down to the clerk's office of the criminal division of state court and check the public computer. And that way mail is not a problem. He does recognize that he does have that record that the state noted. However, he is pledging that he will not miss the court date, that he is determined to take care of this, and he has ambitions to grow as a person. He is a young person. But the $6,000 would be much better if it were something like $3,000. It would not be a signature bond yet. He will be asking to reset his case a week. When I noticed the plea bargain offer, I realized that there was no way to negotiate that overnight. So we would ask to reset that a week and to, in the meantime, make it 3 instead of 6.
All right. So you're asking him to be reset to SAP next week?
Yes, in the meantime, we'll talk with the state about whether we could adjust the offer. Maybe we could reach a negotiated offer, maybe we can't. A negotiated result.
Right, so you're assuming he won't make bonds even with the reduction, Ms. McLean, is what I'm getting, if you're asking him to
Right.
be reset to.
They will try, they will absolutely try to make it, but
Is it possible that this is a plea offer we could discuss right now?
I don't think the state's ready to do that.
Is the state ready to make any type of offer other than the 12 months to serve at this time?
I do not believe so, Your Honor.
All right, Mr. Walker is coming on.
Well, I don't know how the defense could determine what the state is ready to do, but the offer is what it is. So I would leave that at that.
Based on experience.
Well, we ask and we try, and we're trying to see if we could get maybe some plea discussion today. Because if an offer could be placed on the record that the defendant might be able to take, I'd rather do that than reset him to SAP next week. Because I don't typically like to do that. I'd rather us try to resolve or reset to a division judge to move forward. What we're going to do first is I am actually going to arraign this case. I'm going to actually do that because it just is prudent and wise for me to do that. So what I'm going to do for you, Mr. Kimber, is even though your attorney was willing to waive your formal arraignment, I'm going to arraign your case, which basically means I'm going to read the charges against you and you're going to plead not guilty. You understand that?
Yes, ma'am.
All right, Mr. Lawrence Kimber, you've been formally charged with giving false information to a law enforcement officer and carrying a concealed weapon, which has been formally accused by the Solicitor General of Fulton County. Mr. McLean, do you waive a formal reading of that accusation?
We do. We have a copy.
All right, thank you. At this time, the case will be set for trial, and the trial will be scheduled by the state court judge to whom this case is assigned. At trial, you will have the right to an attorney, just as you've had today, and you will not have the burden to prove the charges against you. The state, represented by the Solicitor General, will bear that burden and will have to prove those charges against you beyond a reasonable doubt. If they get a conviction against you, you could face a sentence of up to 1 year in prison or a fine of $1,000 for each charge that can run concurrently or consecutively. Based upon this information that I presented to you today, Mr. Kimber, how do you plead?
Not guilty.
I accept your not guilty plea. I'm gonna slightly reduce Mr. Kimber's bond at this time. For count 1, giving false information to a law enforcement officer, the bond will be $500. For carrying a concealed weapon, it will be $3,500 for a total of a $4,000 bond. Is there anything further from either the state or the defense as it pertains to Mr. Kimber's case?
Nothing.
Nothing further. Thank you, Your Honor.
All right, best of luck to you, sir.
Thank you.
And I'm hesitantly resetting him to SAP next Thursday.
Thank you.
All right. All right. Who do we have next?
We have position number 27, Mr. Lubens Richard.
All right. Good afternoon, Mr. Richard. Your case number is 22 CR 003844G, and what's your charge with willful obstruction of a law enforcement officer with the offense date of June the 15th of 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right, I have that this is a negotiated plea as well, Mr. McLean.
Yes, Your Honor.
All right. At this time, Ms. Backus, will you please put the state's recommendation onto the record?
Yes, Your Honor. The offer is time served, 16 days, balance suspended, and stay away from the incident location.
What is the incident location?
1 second, Your Honor. I'm pulling that up.
Thank you.
He's taking a second. Give me a second. It looks like the incident location is looks like it's 990 Piedmont Avenue Northeast.
And do you know what that is?
That is right. So when the officers approached him, Your Honor, he was in, I believe, like the middle of an intersection and attempting to sell water. So it's a specific location, but it's just 10th and Piedmont Street. So that was where the officer took the report and where the issue ensued.
Okay, so basically he's just supposed to stay away from that.
That's yes, correct.
Okay, all right. All right, Ms. McLean, was that your understanding of the plea?
It is.
All right, Mr. Richard, you understand that the time you served in the Fulton County Jail will essentially close your case, but you still have to stay away from that intersection. You understand that?
Yes, ma'am.
All right. I'm going to ask you a series of questions to make sure that you understand and want to take this plea willingly, all right? Are you under the influence of any drugs or alcohol at this time that will interfere with your ability to understand the proceedings this morning?
No.
Are you satisfied with your attorney's representation?
Yeah.
Did anyone force or coerce you into taking this plea today?
No.
Do you understand that by taking this plea, you're waiving your right to challenge the evidence later in a court of law or to present any defenses you may have had at a court date?
Yes, I understand.
And you understand you will not have a later court date. You're waiving all of your rights that would have come with a court date.
Yes, I understand.
And you understand that you cannot go back to that intersection at 990 Piedmont, or otherwise your case is closed. You understand that?
Yes, ma'am.
As to the charge of willful obstruction of a law enforcement officer, how do you plead?
Guilty.
I accept your guilty plea. If there is nothing further from the state of the defense, that should conclude the case.
Nothing, Your Honor. Thank you.
All right, best of luck to you, sir.
And we are ready for Mr. Gomez, Judge.
All right, so what position was Mr. Gomez?
17.
And that will just be an arraignment, Judge, and we do not need to address bond.
All right, I will now arraign Mr. Gomez's case. Mr. Gomez, your case number is 22 CR 003865D, and what you're charged with simple battery against a police officer or a detention officer with the offense date of June the 14th of 2022. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You have a right to an attorney today, and Mr. Finling is present on the Zoom conference to assist you. Do you understand your constitutional rights and your, do you understand how this proceeding is being conducted today?
Yes.
All right, thank you. At this time, I'm going to formally arraign your case. That means I'm going to tell you what the charge is against you and set it for trial, right? All right, Mr. Stephen Gomez, you've been formally accused of simple battery against a police officer or a detention officer, which has been formally accused by the Solicitor General of Fulton County. Mr. Finling, do you waive a formal reading of the accusation?
I do, Judge.
All right, at this time, the case will be set for trial, and the trial will be scheduled by the state court judge to whom the case is assigned. At this trial, you will have the right to an attorney, just as you've had today, and you will not bear the burden to prove the charges against you. The state, represented by the Solicitor General, bears that burden. If they do get a conviction against you, you can face a sentence of up to 1 year in prison or a fine of $1,000. Based upon this information, how do you plead?
Not guilty.
I accept your not guilty plea. At this time, your case will be reset for trial. All right. I believe that concludes your case, since Mr. Finley, you sure you do not want to be heard on bond today?
Yes, I'm sure, Judge.
All right.
Thank you.
All right, that concludes your case, Mr. Gomez. Best of luck to you.
Thank you, Mr. Finley.
Yes, sir. Thank you, sir.
All right, who do we have next?
Next in courtroom 2, we have position number 10, Mr. Cooper.
All right, good morning, Mr. Cooper. Your case number is 22 CR 0038758, and what you're charged with, one charge I will not sound, and the second charge is criminal trespass with the offense date of June the 17th of 2022. Do you understand your constitutional rights today?
Yes, ma'am.
All right, I understand that this is a non-negotiated plea, Mr. Finley.
This is a negotiated plea, Judge.
Oh, it is negotiated. Okay, I apologize. Mr. Walker, will you put the state's recommendation onto the record?
Yes, sure, I will. The state's recommendation is 12 months to serve 16 days, credit for time served 8 days, balance probated, a mental health evaluation, a sexual deviancy evaluation class, and a stay away from the incident location, which is 40 Pryor Street. And that's to run concurrent on both counts. So
All right.
MHET, SDET, and a stay away.
Okay. 40 Pryor Street, and I always
It's a
ask.
park.
It's a park.
Public park, Your Honor.
All right. I think I have a good understanding. Was that your understanding of the plea offer, Mr. Finley?
Yes, Judge, that is our understanding of the plea offer, of which we do agree to all of it. And would just ask that the probation fees could be waived for Mr. Cooper for a period of time.
All right. And do you stipulate to the factual basis, identity, and venue?
I do.
All right. Mr. Cooper, as you've seen today, I'm going to ask you some questions. Do you understand what you'd have to do if you take this plea today, that you have evaluations and treatment that you may have to undergo? And but the time that you would not have to serve additional time at the Fulton County Jail, but you do understand, has your attorney explained this, and do you wish to go forward with the plea at this time?
Yes, ma'am.
All right. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force or coerce you into taking the plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand that you're giving up your right to a court date by taking a plea at
Yes,
this
ma'am.
time?
Yes, ma'am.
And you understand that you would have had certain rights at a court date where you could have presented evidence in your favor, questioned witnesses, and you're understanding that you're waiving those rights today?
Yes, ma'am.
All right, as to the charges I previously listed, Mr. Cooper, how do you plead?
Guilty.
I accept your guilty plea. If there's nothing further from the state of defense, that will conclude his case, and I will waive 3 months of fees as well for Mr. Cooper.
Thank you, Judge.
All right. Best of luck to you, sir.
You too. Next, we have position number 12, Mr. Culpepper Lucas.
All right, one moment. All right, Mr. Culpepper Lucas, your case number is 18 CR 009300Y, and what you're charged with battery against a pregnant female with the offense date of August the 30th of 2018. Do you understand your constitutional rights?
Yes.
All right. I have the announcement I have, that this is a non-negotiated plea. Is that correct, Mr. Finley?
That's correct, Judge.
All right. Mr. Walker, will you please give me the state's recommendation? What's gonna happen, Mr. Culpepper Lucas, is I'm gonna listen to the state's recommendation, and then I'm gonna hear from your attorney. I'll make my ruling, and you'll determine whether you still wish to take that plea offer at this time. All right?
Yes,
All
Your
right.
Honor, the state's recommendation is 12 months to serve, 60 days, credit for time served, 13 days, balance probated with conditions of FVIP, a stay away, and no further contact. On August 18th of 2018, an argument ensued with the defendant and the victim, who was the mother of his unborn child. At that time, the defendant did become irate. He grabbed the victim by her shoulders, threw her to the ground, and proceeded to stomp her in her stomach. Keep in mind, the victim is pregnant at this time. There were 2 small children that were present at the time of this incident. APD did respond. They spoke with the victim, and they did observe scratches on the victim's neck and arm. The state's recommendation is more than reasonable. And the reason I make that statement, back in 2017, Mr. Culpepper was convicted of simple battery. He was sentenced to 8 weeks anger management by Judge Morrison. While he was out on bond on this case, which he had a pretrial release bond for, which he also FTA twice on this case, while he was not showing up to court, what the defendant was doing was reoffending with the same victim. He was subsequently rearrested with the same victim at the same incident location. Keep in mind, he was out on bond on a pretrial release bond with the conditions of a stay away and no further contact with the same victim. And he was rearrested in March 17th of 2020. That case number is 20 CR 002-084G with the charge of a battery family violence. So again, the state feels as though that the 12 months to serve 60 days and FVIP is more than reasonable. He's already been sentenced to 8 weeks anger management. Obviously, that did not come in handy when he was stomping the unborn child of his mother. So the state would ask that you impose the state's recommendation, Your Honor.
All right, thank you. And you know, my strong suit is never math. How many additional days would he have to serve at the Fulton County Jail if I were to accept the state's recommendation?
17 days, Your Honor.
You would have an additional 17 days. All right, Mr. Finley?
Yes, Judge. As previously stated, this is a non-negotiated plea with jail time at issue. I am asking for 30 days, which would mean he would only have 1 additional day. Now, obviously, Judge, I do completely understand, ASG Walker, the seriousness of these charges and the history. I did speak with the alleged victim, Ms. Constance, and the jail time being at issue revolves around her currently being pregnant with his child. She's due any day. She also 2 days ago suffered a dislocated shoulder and is supposed to have surgery. I did speak with her and she did confirm this, and she is on the Zoom and did want to speak on his behalf. He has 5 kids. He is a mobile mechanic, and for the past 2 years has worked 7 days a week, helping provide for himself and his family. This did happen in 2018, has not been in trouble since. Once again, Judge, his girlfriend really stressed the importance of him being out because she has a dislocated shoulder and kids to deal with and is currently pregnant. And there's just kind of a lot of moving parts, and she really needs him to function. And she is here once again, Judge, and would
I'll
like
sound for her in a moment. What was her name again?
Constance Philo.
Okay. Before I go to Ms. Philo, Ms. Harrison, can I have the complete history, please?
Judge, I apologize. I don't have a history on this defendant.
Okay. Mr. Walker, I know you gave me parts of the history. Do you have the complete history?
I do have the complete history. The only other charges I saw were abandonment charges, which we know are child support cases. I believe he had a suspended license charge and maybe a marijuana charge. But the only relevant history that I saw was the simple battery conviction in 2017. I do have that case number 16 CR 010260E. Again, he was sentenced in front of Judge Morrison in 2017, 8 weeks anger management. And again, while he was out on bond on this case, and while there was a stay away and a no further contact with the victim, he did reoffend. And again, that is an open case, case number 20 CR 002084G. Again, the state is very concerned about the victim's safety. We all understand the cycles of violence. I understand that the victim may try to minimize today, but at the end of the day, they have 2 open cases. I guess both of the cases occurred while she was pregnant. And the state has grave concern for her safety. He's already violated the stay away. He's already violated the no further contact. And today he's entering a plea to battery on a pregnant female. So I know you asked for the history. I gave you a little bit more, but
History with
the
a little
state's-
sauce. I'll let Mr. Finley respond after I hear from the victim. Ms. Philo, if you would like to speak, this is your opportunity. So you would have to raise your right hand. I need to swear you in. And I'm gonna ask, okay, raise it as best you can. That's good. You're still muted though. So when you begin speaking, I will not be able to hear you. So I need you to unmute your screen by clicking that, I guess the little microphone button down in the corner. All right, do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, what would you like to tell the court at this time?
Actually, we aren't together anymore. We're separated, so there's no fear. I actually stay in Douglasville, Georgia, and he resides in the city of Atlanta.
Right.
So the only contact we actually do have really are just the kids.
All right. So you don't have any fear of the defendant, is what you'd like the court to know at this time?
Correct.
All right. All right, Mr. Finley, I allow Mr. Walker to make additional presentations. Is there anything further you'd like to say?
Just that we could have a third-party transfer of the children as well, Judge.
All right, so your recommendation is that, does the state object to the third-party transfer? I'm just curious, Mr. Walker.
No objections to third-party transfer, Your Honor.
All right. If Mr. Culpepper Lucas takes this plea today, I'll accept the defense's recommendation. He would have 1 additional day to serve at the Fulton County Jail. Does he want to take this plea at this time?
Would you like to move forward, Ms. Culpepper? Yes, Judge.
All right, and he understands the requirements. He'll have to serve 1 additional day. I'm gonna order the third party transfer. He has to have absolutely no contact with the victim. He must complete that FLIP course. And he understands all the requirements, Mr. Finley?
You understand the requirements, Mr. Culpepper?
Yes.
Yes, Judge.
All right. I'm gonna ask you a series of questions to make sure that this is a voluntary plea, all right?
Yes.
Are you under the influence of any drugs or alcohol at this time?
No.
Are you satisfied with your attorney's representation?
Yes.
Did anyone force or coerce you into taking this plea today?
No.
Did you understand that by taking this plea, you're giving up your right to a court date?
Yes.
And you're prepared to waive the right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
All right, and you understand the requirements of the sentence and the course that you're gonna have to take?
Yes.
All right, as to the charge of battery against a pregnant female, how do you plead?
Yes.
All right, I accept your guilty plea. If there's nothing further from either party, that will conclude his case.
Thank you, Your Honor.
All right, who do we have next?
Bernard, position 20.
All right, Mr. Kennard, your case number is 22 CR 003861B, and what you're charged with loitering and prowling with the offense date of June the 16th of 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right. Is it Mr. Walker this time? No. Ms. Backus, I believe. Will you put the, or is it, yes, will you put the state's recommendation onto the record?
And I'm sorry, Your Honor, this is position
20.
This is position 20. I'm sorry. The recommendation in this case is 12 months, 30 days to serve, credit for time served, 15 days, balance suspended, and stay away from the incident location. And Your Honor, I'm pulling up that incident location, so give me a minute. That's 20 pages, okay. The incident location is 378 9th Street, Atlanta, Georgia, 30309.
Right, and I always ask, what is that business? Make sure it's not a healthcare or some essential service.
No, Your Honor, this is actually a residential location.
Okay. All right. Mr. McLean, was that your understanding of the plea offer here today?
Excuse me, that's number which?
20.
Yes, it is, Your Honor. I'm sorry, I looked away for a second. That is Lee Kennard. I reviewed the paperwork, and that is our understanding, and we stipulate to the necessary elements.
All right, thank you.
Your Honor,
Yes.
my apologies, but in this particular incident, there were a couple of locations that were included. So the defendant went from one house to another. And so there are actually two, it looks like there are two stay away locations.
All right, what were the, what are both the addresses?
So 378 9th Street Northeast. They also have 900 Taft Avenue Northeast, that's TAFT. And then they have 900 Argonne Avenue Northeast. And those are all 30309. I believe they're all right across the street from each other.
Okay, so these are all homes that he needs to stay away from.
Correct.
All right. And you understand that, Mr. Kennard, the time you serve in the jail, I believe will close your case. However, you cannot go back to any of those addresses. You understand that?
Yes, ma'am.
You need to stay at least 2 football fields away from each one. You understand that?
Yes, ma'am.
All right. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force or coerce you into taking a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
Do you understand that by taking this plea, you're waiving your right to challenge the evidence in a court of law and the right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
Are you prepared to waive these rights?
Yes, ma'am.
And do you understand the requirements of the sentence that you need to stay away from those locations?
Yes, ma'am.
As to the charge of loitering and prowling, how do you plead, Mr. Kennard?
Guilty.
I accept your guilty plea. There's nothing further from either party that should close out your case. All right, best of luck to you.
Thank you, ma'am.
All right, next we got number 2, Ms. Anderson.
And,
All right,
and Judge, I do need to speak with Miss Anderson when I tried to, she was in medical.
all right. So can Mr. Finley be put in a breakout with Miss Anderson? And can we go to another position?
Position 21, low.
All right, good morning, Mr. Lowe. Your case number is 22 CR 003860C. And once you're charged with possession and use of drug-related objects, public drunkenness, and willful obstruction with the offense date of June the 16th of 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right. The announcement I have is this negotiated plea.
Correct.
All right, Ms. Backus, what is the state's recommendation?
State's recommendation is 12 months, serve 30 days, credit for time served 15 days, balance suspended, and stay away from the incident location, which I'm pulling up, and I'm sorry, Your Honor, I have to
That's
pull these up
fine.
as they come up.
That's fine.
So this is really just another area, right? It's another like intersection. So it is the intersection of Ralph David Abernathy Boulevard Southwest and Pulliam Street Southwest.
All right.
So I guess no loitering in that area.
So he was in the street essentially, just walking
Correct.
down the road. All right,
Correct.
and he, no particular business, so he just needs to stay away from that intersection. All right.
Correct.
And it was RDA, and what was the other street?
Pulliam Street Southwest.
Okay. So, Mr. Lowe, if you take a plea, you can't go back and hang out or stand by that intersection. You understand that? He's muted at courtroom 2. You understand that?
Yes, Your Honor.
And you know you can't go back there. Do you still wish to take this plea today?
Yes, Your Honor.
All right, Mr. McLean, do you stipulate to the factual basis, identity, and venue? And what's that your understanding of the plea offer?
We do so stipulate, Your Honor.
All right, I'm gonna ask you the same set of questions, Mr. Lowe. Are you under the influence of any drugs or alcohol at this time?
No, Your Honor.
Are you satisfied with your attorney's representation?
Yes, Your Honor.
Did anyone force or coerce you into taking this plea today?
No, Your Honor.
Did anyone offer you anything in exchange for taking this plea?
No, Your Honor.
Do you understand that by taking this plea, you're waiving your right to challenge the evidence in a court of law or to present any defenses you may have had?
Yes, Your Honor.
And you're prepared to waive your right to a court date?
Yes, Your Honor.
And you understand you cannot go back to the intersection by any means?
Yes, Your Honor.
All right, as to the charges I previously listed, how do you plead?
Guilty.
I accept your guilty plea at this time. I believe that will conclude your case. There's nothing further from either party.
All right, thank you, Your Honor.
All right, best of luck to you. Don't go back there.
Yes, ma'am.
All right, who do we have next?
25 Phillips.
All right, good afternoon, Mr. Phillips. Your case number is 22 CR 004024F. And what's your charge with theft by shoplifting with the offense date of April the 10th of 2020? Do you understand your constitutional rights?
Yeah, ma'am.
All right. Let's see, what do I have with this one is? Is this a negotiated plea?
It
It
is.
All right.
should be a negotiated plea. yes,
All
Your Honor.
right, Ms. Backus, what is the state's recommendation?
Your Honor, the state's recommendation is time served 40 days, balance suspended, and stay away from the incident location. The incident location is, let's see, it is 2784
Recording in progress.
Donald Lee Howell Parkway. And the police report didn't actually give the name of the store. I'm actually going to look that up right now, but that is a store.
Probably, is it a Family Dollar? I believe, I think I remember that address. You said 2781,
2784 Donald Lee Howell.
84. Let's see. I just want to always.
Looks like it's is it a Texas?
It's a gas station. Okay.
Yes.
All right. Was that your understanding, Mr. McLean?
Yes, Your Honor.
And do you stipulate to the factual basis, identity, and venue?
We do so stipulate.
All right. Mr. Phillips, I'm gonna ask you some questions as well, all right?
Mhm.
All right. Are you under the influence of any drugs or alcohol at this time that will interfere with your ability to understand what's happening today?
Yes.
You are under the influence of drugs?
Oh, no, no, I ain't hear you, man. No, I ain't on this phone, no drug.
Okay. And you're sure about that?
Yeah,
All right. Are you satisfied with your attorney's representation?
yeah,
Did anyone force or coerce you into taking this plea today?
no,
Did anyone promise you anything?
no,
And you understand that by taking a plea today, you're waiving your right to challenge the evidence against you in a court of law?
say it again?
You're giving up your right to go to court by taking a plea today. You understand that?
Yeah,
And you're giving up the requirement that the state prove these charges against you beyond a reasonable doubt?
yeah,
And you're prepared to give up that court date where you may have been able to present something to not have this charge against you? You understand, you're giving up your right to a court date, you understand that?
yeah,
And you understand that you absolutely cannot go back to the incident location at 2784 Donald Lee Hollowell? You understand that?
yeah,
Other than that, the time you served at the jail should close your case. And you understand that if you have any other open cases, this charge may affect those cases. You understand that?
yeah.
As for the charge of theft by shoplifting, how do you plead?
Guilty.
I accept your guilty plea at this time, Mr. Phillips. Do not go back to that location, all right? Best of luck to you, sir. What do we have next?
Position 28, Sheridan.
All right.
And we
Good
are ready for-
afternoon. Are you Dean Sheridan? I mean, good morning. I'm not used to the morning. Are you Dean Sheridan?
I am.
Your case number is 17 CR 003730F. And what you're charged with driving under the influence of alcohol, reckless driving, and failure to change address on a driver's license with the offense date of August the 19th of 2015. That was terrible. Do you understand your constitutional rights?
Yes,
All right. The announcement that I have is that this case, that a bond hearing is required and that I'm just arraigning this case. Is that still correct, Mr. McLean?
Yes, Your Honor, the case is from 2015. I wouldn't be surprised that it might have already been
Oh,
arraigned,
is it already been arraigned? Ms. Brooks, are you able
but
to
I
check for me?
don't know for a fact.
We'll check. And while that's going on, if Ms. Backus could begin her bond arguments.
Yes, Your Honor. So it looks like on August 19th, an officer was traveling down Piedmont Road Northeast when they stopped at the red light of Piedmont and Lindbergh. They observed a white vehicle on Lindbergh Avenue, stopped at the green light. The officer watched the vehicle for a short period of time and then began using his spotlight in an attempt to gain the driver's attention. The traffic light cycled to red, and I guess then it turned green. The car never moved. So the officer drove through the gas station parking lot and pulled onto Lindbergh Avenue. And so once he was parallel with the driver's window, he shined the light into the car and observed that the driver's head was slumped forward. His chin was on his chest, eyes closed. And while the light was shining through the window, the driver woke up and looked around with a confused expression. And at that time, the officer exited his vehicle. Of course, he asked for the driver's license, and he was met with the responses of, instead, why did you pull me over? And so he wasn't necessarily cooperative. He just said that he had his head down because he was texting his girlfriend. And then, I'm sorry, this is a fairly long, one moment, Your Honor.
All right.
The officer honestly began to just use his expertise and his signs to realize that the defendant was not cohesive. He wasn't really coherent, and that he asked him to do an eye test, file his finger. Looks like he wasn't able to do that smoothly. And he was also swaying. and he couldn't keep his head straight. He couldn't focus on the stimulus. And so the officer, after observing all these, eventually put the defendant into custody. He also could not walk a straight line, Your Honor. And so, Your Honor, this is the defendant's, I believe he has 7 DUIs from 1994 up until now, but 3 DUI convictions. And so, Your Honor, with this being the 4th DUI within a 10-year span, 12 months to serve is seemingly appropriate. He's a danger to himself. He's a danger to the community by getting on the road under these conditions. And so because he's had so many in such a back-to-back history, 12 months to serve, we feel as though is an appropriate recommendation, Your Honor.
Okay. And in light of that, what is his current bond?
The current bond is $2,500 surety on count 1, a $4,000 surety on count. So $2,500 on the DUI, $4,000 surety on the reckless driving, and I believe a $1,000 surety on the failure to change name or address on the driver's license. So he's got a $7,500 surety right now. And we're asking that that bond stay the same.
All right, thank you. Mr. McLean?
Your Honor, the key to the request from the defense for a bond reduction is to visualize a calendar for each year since 2015. One of the DUIs or more, I don't know. I believe one of the DUIs the state has mentioned was had occurred and was adjudicated since then. I don't know how this 2015 case dropped through the cracks. He does not drive. He has a home improvement company. When he needs to get to a customer to estimate a job, he takes Uber or Lyft. This was 7 years ago, and he had a private practice attorney handle a case for him since then. How on earth this case never got taken care of is a mystery. But the emphasis that we make is that the timing of it. So we would ask the court, unusually, in this circumstance, even though it's a DUI, we would ask the court to consider a signature bond, or if not that, a $1,000 or $2,000 total bond.
All right, thank you. Ms.
And Your Honor,
Harrison,
can I briefly respond?
1 second. Ms.
Okay.
Harrison, are you here? Do you have, I would like the complete history if you have this one. You're muted, Ms. Harrison.
We're having some issues with our GCIC, so I don't have that history.
Okay. Ms. Backus, please give me the complete history with including the years of each DUI.
Yes, ma'am. So they're very remote in time, but there was a DUI, it looks like in 94, 96. The one in 2015 time, it looks like, I guess that's this case. And then there was a 2016 DUI conviction, a 2019 DUI hit and run and endangering a child. That one, time expired, so there was an arrest. And then there's the 2022. Let me pull this up just to get clarification on this 2015.
Yeah, I just want to know how remote are the DUIs?
Well, I do know for sure, Your Honor, that he had a DUI conviction in 2016, but I'm pulling up the GCIC right now.
That is correct. That's the one that was handled by the private attorney.
Okay.
Okay, Mr. Walker, if you wanted to, while we're looking for that.
Just
go ahead.
briefly.
Very briefly.
I heard counsel say it's a mystery how this didn't get resolved, but the point is, if you have court and you don't show up, you have a FTA, you get a bench warrant. I just very briefly looked at Odyssey and I counted 3 bench warrants or 3 FTAs on this case alone. So this is not a mystery, and under no circumstance should a defendant refuse to come to court, and then when they finally get picked up on a bench warrant 7 years later, say, hey, I know I haven't been to court in the last 7 years, but that should be viewed in my benefit and I should be given a signature bond. If you ask me, it should work in quite the opposite. You don't reward good behavior by giving someone a signature bond when they FTA'd on a case 3 times. And I know we've went over the defendant's history, but this is not his first DUI. This is not his first rodeo. He's no stranger to the criminal justice system. It's no mystery as to why this case is a 2015 case. It's a 2015 case because he's FTA'd at least 3 times. So I just wanted to respond because the state takes exception to, oh, we don't know how this slipped through the cracks. If you have court and you don't show up, you get an FTA. It's that simple. We all know that. But
Understood, Mr. Watson.
that's all, Your Honor. Thank you.
Thank you.
So, Your Honor,
He's been in jail 1 day. Is that correct? He was picked up yesterday? That's what I have on this calendar. Is that correct? That can't be correct. How long?
That can't be correct.
That can't be correct. This calendar says 1 day. How long has he been sitting in jail?
looks like, hold on 1 second.
When was he booked in?
So he was booked in. Well, actually, so he got arrested 1 day back in 2015, but I'm not sure what the
Right, how long has he been sitting there
on this
He's
one.
been there for 14 days. Okay, that makes more sense. All
Your
right.
Honor.
Yes, very briefly.
So as to the criminal history, there was a NOLO DUI, like I said, in 94. There was then another DUI conviction in 96. There was then let's see, was this actually simple assault, obstruction? No, this was all no process. I'm sorry, simple battery. Let's see where the DUIs. Okay, so 2015, yes, this is there's a DUI arrest in 2015. Then there's the 2016 DUI conviction, and then there is a 2019 hit and run DUI, endangering a child, which time expired on those. And then in 2022, that is when he was picked up for, I guess, for the 2015 case.
Okay, I think I've got it. Thank you. All right, at this time, the breakdown of the bond will be as follows. The 2,500 will remain as set on the DUI. The reckless driving is a $3,000 bond. And the failure to change the address on the driver's license will be a $250 bond for a total of a $5,750 bond. And he is to not drive as a condition of this bond at all. And he is to have no weapons, drugs, or alcohol, and no new violations of Georgia law, of course. All right, so the 2,500 on DUI remains as set.
Your Honor, count 1 remains the same and count 2
It's
reckless
reduced to
driving is
3,000,
3.
and then the count 3 is reduced to 250. All right.
Thank you.
Oh, it's a 62? I'm so bad at math. I'll go with whoever's math it is.
62, okay.
Okay. No, that's not right, is it?
No, let's see.
No, I think you were right the first time, Your Honor.
Yeah, 5750, that's right.
2,500, 3,000, 250.
That's 5750.
Right.
I'm bad at math, so let's triple check it. 25.
25
All
plus
right.
5,500 plus 250 is 5750.
Yeah.
Your Honor, we all went to law school because we're not good at math. But
Math is not my strong.
But you're right. You're right.
2,500 and 3,000. 3,000. All right. That will conclude Mr. Sheridan's case.
Thank you, Your Honor.
Best of luck to you, sir. Who do we have next?
Going back to number 2. We're going number 2, Ms. Anderson.
Okay.
All right, Legends.
Oh, all right. So we are going to Ms. Anderson. That's where we're going?
Yes,
All
ma'am.
right. All right. All right, I have that. We're gonna, Ms. Anderson, your case number is 22 CR 002676F, in which you're charged with simple battery with the offense date of May the 2nd of 2022. You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney at this proceeding. Do you understand your rights?
I do, ma'am.
Thank you. All right, I have hold for announcement.
Yes, Judge. This is going to be a non-negotiated plea with balance, probated balance suspended at issue.
All right. Ms. King, good to see you this morning. Is this your case?
Yes, it is, Your Honor. Good morning.
Good morning. What is the state's recommendation?
The state is asking for 12 months to serve 90 days, credit for time served 54 days with the balance probated, at MHE, 8-week anger management, ADET, and no further contact with the victim, Ms. Frederica Kellam, FREDRICKA, KELLAM, and her daughter, Nyla Anderson, A''NYLAANDERSON.
All right, and how much time would Ms. Anderson have to serve at the Fulton County Jail? Additional, would she have any additional time to serve? I'm assuming not.
No additional time, Judge.
No additional time. I'd like to hear the factual basis, Ms. King.
Yes, Your Honor. On May 2nd of 2022, at around midnight, Officer Cook was dispatched to a dispute call at 23 Jesse Hill Drive Southeast. And when he arrived, he spoke with both victims in the case, and they were stating they wanted to press charges against the defendant. They were walking down the street together, and when the defendant passed them, he grabbed the young Nyla Anderson and would not let her go. After some time, he finally let go, and the defendant threatened to stab them. And then he said that he only wanted to kiss the little girl's hand, Your Honor. The victims called 911, and when they responded, they were able to apprehend the defendant and take him into custody. He has a concerning criminal history, Your Honor, from armed robbery convictions all the way to armed robbery arrest and battery arrest, but he does have criminal trespass and obstruction convictions, Your Honor. This was a random act of violence, and which concerns the state. They did not know each other, and he just randomly grabbed this young lady. She's traumatized from what we've spoken to her mother about the condition of the young lady. She needs therapy, different things like that. For that reason, Your Honor, we feel that the recommendation is appropriate.
All right. I'd like the full history. Do you have the full history, Ms. King?
I do not have the full history. I know there's 31 cycles, but I only wrote down the violent ones. So we have an armed robbery arrest from 2010, simple assault arrest from 2003, a simple battery arrest from 2002, another simple battery arrest from 2005, and a battery arrest from 2008. Unfortunately, the GCIC does not give the dispositions of those arrests. Those could very well be convictions. For the convictions that I was showing on the GCIC is a criminal trespass and obstruction from 2004 and a criminal trespass from 2013. But due to the quantity of the cycles, 31, Your Honor, this shows the defendant is not following the law, has no interest in following the law, and will continue to break the law, Your Honor.
All right, thank you. Mr. Finley?
Yes, Judge. Could we hear a GCIC if there is?
Oh, Ms. Harrison, do you have this one, GCIC?
Yes, Judge.
Oh, good. All right. I was afraid to ask.
30 cycles. Last arrest was March of 2013 for criminal trespass in DeKalb County. That was a misdemeanor conviction. GCIC indicates a 2013 theft by shoplifting misdemeanor conviction. Outside of that, his history is outside the 10-year period.
All right, thank you, Ms. Harrison. Mr. Finley?
Yes, Judge. And while I do appreciate Ms. ASG pointing out the criminal history or lack thereof, a recent criminal history, I heard about a couple arrests, but I didn't hear about those convictions of those violent alleged crimes. We just heard a criminal trespass from 9 years ago. So while I understand and I hear that she's likelihood to reoffend, I'm not good at math either, but 9 years, well, I don't know, what is that, like 2,700 days now that she's gone without a violent arrest. She said she was trying to get the alleged victim's attention and she grabbed her arm. Should she have done that? No, but I do not think it was the most egregious thing. She takes responsibility. She has served 54 days. I am asking for the balance to be suspended. The state is asking for the anger management, the mental health evaluation. She does not have any money. She does not have any family, any friends. She's no phone. She has nothing. So I feel in 9 years, she showed that she's walked a straight path. And I think any of these conditions are a recipe for failure, which I think is unfair to Ms. Anderson. And I think she has served her time, 54 days now, sitting within her cell. So I am asking for the balance to be suspended, Judge, as I feel like these conditions are just a recipe for failure for Ms. Anderson.
I understand that concern, Mr. Finley, but if your client takes this plea today, I'm going to accept the state's recommendation in its entirety. Does your client want to move forward and take this plea at this time?
So, Ms. Anderson, so what the judge is saying that, so you will have to complete a mental health evaluation, the 8-week anger management, and alcohol and drug.
I would like to say,
Don't say too much, Ms. Anderson.
Ms. Anderson,
Yes.
I strongly advise having your best.
y'all have the wrong person. None of that is me.
Okay, I don't think we're in a position to take this plea today. If
Well, because I'm not the one.
Okay.
I am a female.
Ms.
And
Anderson.
I've done none of those things that you talked about.
Okay.
I've never had a gun. I've never had a knife.
Okay, Ms. Anderson, please stop talking. You're interfering with Mr. Finley's ability to assist you, okay? I don't think we can take this plea today, Mr. Finley, in light of what your client just said. Has this case been arraigned? And would you like to be heard on bond?
I was sitting on the church steps. I'm in a wheelchair.
Could we mute if possible? Hold on 1 second, Ms. Anderson. I'm trying to best represent you, ma'am. Yes, Judge, if we could arraign this.
Okay.
And if we could get this put on the upcoming calendar so we could readdress possibly taking a plea.
Okay. Has this case been arraigned? Oh, I'll just arraign it. We'll just assume it has not been. Ms. Shawn Anderson, you've been formally charged with simple battery, which has been formally accused by the Solicitor General of Fulton County. Mr. Finley, do you waive a formal reading of the accusation?
I do, Judge.
At this time, please mute medical just temporarily. This case, Ms. Anderson, will now be set for trial, and the trial will be scheduled by a state court judge to whom your case is assigned. At this trial, you will have the right to an attorney, and you will not have to prove these charges against you. The state bears that burden. If they do get a conviction against you, Ms. Anderson, you could face a sentence of up to 1 year in prison or a fine of $1,000. Based upon the information that I presented to you, do you plead not guilty to the charge of simple battery, Ms. Anderson? Please unmute her at medical. I just need her to indicate. Ms. Anderson, please do not say too much, but do you plead not guilty to the charge of simple battery?
I'm not guilty, ma'am.
All right, I accept your not guilty plea.
They gave me a signature bond at first.
Okay, Ms. Anderson, please let me advocate for you, ma'am.
Okay, so we've properly arranged her case. What is her current bond?
It's a 2,000 surety, Your Honor.
All right.
And the state requests that it acts, that it stays remain as set, Your Honor. Again, the state is gravely concerned due to this being a random act of violence against a very young lady that has been traumatized. The state is concerned for the community at large.
I understand that. What were the special conditions attached to that bond? Were there any?
Let me see if there's a stay away.
I guess my questions were there any evaluations ordered? I'm assuming not. Oh, there was. I see that there was an evaluation ordered by Judge Morrow. Did that evaluation ever take place? She was on the competency calendar?
On June the 16th, she was reset to SAP.
Okay, what happened there? They found she was competent? I'm assuming so. Hold 1 second. Mr. Finley, do you know what happened? Judge Morrow ordered the MHET in May, and it appears she was on the competency calendar and then reset to SAP. I'm assuming she was found competent. Is that what
The
happened?
judge, I'm trying to look through the events on Odyssey, and I'm
Okay.
not trying to, I'm assuming so, but I can't.
I mean, that's the only
get with the
resolution.
fact,
Mr.
yeah.
Walker, would you like to
I'm
weigh
just
in?
showing that something was received June 13th of this year. I don't know if Mr. Howard is on the line, but he would be the one with the answer if she were to be found competent.
Yes, Judge. I hate to talk about this in open court, but well, in her case,
breakout room.
In her case, right there,
Yeah,
it was done, and it was determined that that she could proceed, Judge. So that's why.
Okay.
Yes.
Okay, so.
It was completed.
All right, well, it appears that a plea is still not appropriate at this point. All right, so what we're gonna do, we will reset. I'm inclined to reset her to a division judge, Mr. Finley, only because it does not appear from her statements today that it sounds as if she feels as if she's not guilty here. Let me hear your request, Ms. Finley. You're asking that she be reset to another SAP calendar?
Well, if we're addressing bond, Judge, I am going to ask for a signature bond. On this.
Okay, but before we go to bond, I want to talk about where you think it's most appropriate to reset her, Mr. Finley. We'll go back to bond. I'm not gonna, of course, we'll address that. But I'm just concerned that it seems as if your client, vehemently protects and objects to the charges against her. So do you believe that it's most appropriate to reset her to an SAP? Or just set her for a division judge, maybe whereby motions or other hearings could take place?
Judge, if we could reset her just to another SAP, just so I can discuss what she wants to do, because I kind of got mixed.
All right, the case has been arraigned. I'll reset her for SAP next week. Let's hear bond arguments. The state has requested the $2,000 bond remain as set. Ms. King, did you ever find out if there were special conditions?
Yes, I just saw the MHET and no drugs, alcohol, weapons.
Okay. All right, and Mr. Finley, you're requesting a signature bond?
Yes, Judge. Would you like me to proceed?
Yes, please proceed.
Yes, Judge. So I am asking for a bond modification on behalf of Ms. Anderson. As of right now, her bond is a $2,000 surety bond, which through a bonding company would be about $200 plus tax. Ms. Anderson did say that she is going to have housing lined up, and that should be lined up within the next couple weeks, which makes me feel confident that she will return to court. She'll have a stable home. As previously stated, she has previously been homeless, and she hasn't made money in the last 54 days, obviously, because she's been incarcerated on the same bond. She has no phone, no car, and no money. So this $200 bond might as well be $1 million because she has no opportunity and no chance to pay that. So I am asking for a signature bond on behalf of Ms. Anderson. If she wants to fight this charge, then I hope so. I hope that she can do this from the outside instead of in, Judge.
All right, thank you, Mr. Finley. I'm gonna slightly reduce Ms. Anderson's bond. It'll be $1,000 surety bond with the same conditions. And I will reset her to SAP next Thursday in the hopes that there'll be some resolution of this case.
Thank you, Your Honor.
Understood. Thank you, Judge.
All right. Best of luck to you, Ms. Anderson. That concludes your case. Please follow up with Mr. Finley regarding any questions you may have. All right.
Position 31, Towns.
And Judge, can you say what the condition was on that bond? Was it a,
It was a.
or there was, I'm sorry, my bad. Yeah.
It's gone.
Yeah, gotcha.
Okay. It was no contact with either of the victims, but there was no stay away. All right, Mr. Towns, your case number is 18 CR 007696E. And I will not sound the charge with the offense date of April the 2nd of 2018. Do you understand your constitutional rights? You do?
Yes.
Okay, thank you. I have that this is a negotiated plea.
Yes. it
All
is.
right, Ms. Backus?
Yes, Your Honor. The state's offer is 12 months, served 30 days, credit for time served 15 days, balance probated. We're going to have the SDET evaluation and stay away from all MARTA locations.
Okay. And that was your understanding, Mr. McLean?
Yes, Your Honor, it is. And I explained to him the elements.
All right, and you stipulate to the factual basis, ID and venue?
We do.
All right. I'm debating whether I need to hear the factual basis of this case. Is there a way to mention it in a non-sensitive way, Ms. Backus, such that the charge is not?
Sure. I'll do my best. I essentially, an officer just responded to a call. And they met two witnesses at the North Springs MARTA station. And they just observed the nature of what the defendant was doing. And so they saw this occurring for about 30 minutes. And so that's what the witnesses told the officers. And so at that time, they took him into custody.
Okay. All right, Mr. Towns, I'm going to ask you some questions to make sure that you're taking this plea voluntarily. But you understand you can't go back to MARTA at all? You understand that?
Yes. Yes.
You understand that? Okay. If you do, the jail will welcome you right back with open arms, all right? Are you under the influence of any drugs or alcohol at this time?
No.
Are you satisfied with your attorney's representation?
Yes.
Did anyone force or coerce you into taking this plea today?
No.
Do you understand that you're giving up your right to a court date by taking a plea today?
Yes.
And you're willing and ready and prepared to waive that right?
Yes, absolutely.
And you understand you can't go to MARTA, but otherwise the time you served in the Fulton County Jail should close your case. You understand that?
Yes.
All right, as to the charge that I did not sound, but I'm sure you're aware through your attorney, how do you plead, Mr. Towns?
Guilty.
I accept your guilty plea. If there is nothing further from either party, that will conclude his case. Is there anything further?
Nothing, Your Honor. Thank you.
Thank you. Best of luck to you, Mr. Towns. All right, who do we have next?
We're completed here in courtroom 2, Judge.
All right, have a great afternoon.
Thank
Is
you.
there any other, are there any other positions at medical or any other place before we move to our competency calendar?
Let's see, I was hoping at one point to talk to number 34 on Zoom.
Okay, before courtroom 2, are we? Oh, that's true. Ricky Williams was supposed to be in medical. Is Mr. Williams at medical? I see medical is still on the screen.
You probably went to go get him.
Okay.
And there was also, Judge, position 15, Mr. Gaines. I'm not sure where he is, but I needed to speak with.
Is Mr. Gaines in medical by any chance?
And also 16, Glenn. I missed.
All right, well, let's wait for medical to come online. Maybe that's where the Mr. Walker, you look very confused. Is there?
Yeah, well, I had a position 33, which is a female. So I don't know, is Union City on the line or the female?
I see South Annex is on the line.
So position 30.
I'm
PG
assuming.
Howard reached out to me about that case. So we worked out a plea agreement. So I anticipate that'll be a negotiation.
I was, even though they're finished at courtroom 2, I was assuming we still have positions at medical and South Annex.
Yeah, I can call South Annex.
If you could.
And position 33 may be medical, because I think there was some MH
Right,
concerns, so it could be either or.
No, she's at South Annex, Mr.
Okay.
Mr. Yes.
I was just assuming we would go to the South Annex positions. And then courtroom 2 could be excused once courtroom 2 assists me perhaps with where the other defendants are.
Now, I do have an inquiry on number 18. Yesterday, there was no availability for an interview because I was told that he wasn't coming out. So that was a slightly different posture than number 34, where there simply wasn't enough in the way of 4 deputies.
At courtroom 2, is there any announcement for position 18 as well? Mr. Cordarius Hayes?
Is he simply not participating?
Mr. Hayes, let me see what floor he's on.
PD McLean, I just checked, and I think he may be MH. He was on the competency calendar. I'm assuming he's been found able to proceed, but I do believe there are MH issues, which may explain your concern.
Right, I had 2 South.
Yes, I can go get them. It looks like they didn't get them. So
Okay, is there anybody else that might be missing that we might, so we're gonna get position 18. Who else might be missing from this calendar? Is there an announcement for where position 5 is? Is 5 not coming? Shannon, but, that might be a Union City position. All right, let's proceed with the Union City positions.
Judge, if I may. Position 5, Shannon Boswell, is actually a male.
Okay.
I did speak with him yesterday. But
Okay.
position 15 is also a male, but I was unable
To speak
with him yesterday.
Okay, so we're gonna get Mr. Hayes. Will we be able to get Mr. Gaines and Mr. Gaines as well? What about 14? Oh, 14 was released. While we figure that out, let's try to go to the South Annex positions. Hopefully we'll be able to figure out where the rest of the people are. Good morning, Your Honor. Good to see you. Who do we have first at the South Annex?
Okay, one announcement. Miss Antoinette Glenn, she was released on June 18th.
Okay.
And Mr. Finley, I'm calling you so you can talk to your client.
Okay, thank you.
And we have positions, Ms. Spikes in the chair.
Okay, Ms. Spikes.
That's position 30.
All right. All right, good morning. Are you Valenia Spikes? Valena Spikes. Is it possible for all defendants at the South Annex to come forward so I can read everyone's rights at once?
Come and stand in front of the camera.
All right, good morning, defendants at South Annex. My name is Judge Melanie Williams. Today is June the 30th, and this is the state all-purpose calendar. This particular proceeding is being broadcast over the internet as a live stream. That means any member of the public can log on and watch this particular proceeding. Today at these hearings, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. Thank you all for listening to those rights. That will help us move through more efficiently. You can be seated. We'll now go to position 30. Ms. Spikes, do you understand those rights as I just explained them to you?
Yes, ma'am.
All right, in this case, you're charged with criminal trespass with the offense date of June the 4th of 2022. The announcement that I have is this is a negotiated plea. Is that correct?
That is correct, Your Honor.
All right, Ms. Backus.
The offer from the state is time served, 14 days, and stay away from the incident location. The Incident location is. Sorry, Your Honor, this is, it's 6701 Shannon Parkway, the Garden Inn Motel in Union City.
Okay,
Yes, ma'am.
all right. And can I just have very briefly the factual basis, Ms. Backers?
Yes, officers were dispatched to the Garden Inn Motel. Upon arrival, the motel owner said that the defendant kept trespassing on the property despite numerous warnings. Officers confirmed that she had an open trespass case for this property from February 2022. And when officers asked the defendant why she was on the property, she said she was helping a friend who lived on the property. And when attempting to detain the defendant, she became combative and resisted arrest. And after struggling, they did have to pull their taser. They were finally able to get her into cuffs, Your Honor. But yeah, she just needs to stay away from that location.
Yes, ma'am.
All right, and if you take this plea today, Ms. Spikes, you understand that the time you serve in the jail will essentially close your case, but you cannot go back to that hotel. You
No
understand that?
problem. Yes, ma'am.
All right, Mr. McLean, was that your understanding of the plea offer?
So
My case, Judge.
that's Mr. Finley.
Oh, it's Mr. Howard's case. Okay, Mr. Howard, was that your understanding?
That's our understanding, Judge. We stipulate to a factual basis, venue and ID. That's your step.
All right, Ms. Spikes, I'm gonna ask you some questions just to make sure you're taking this plea voluntarily, all right?
Yes, ma'am.
Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force or coerce you into taking this plea today?
No, ma'am.
Did anyone offer you anything?
No, ma'am.
And you understand that by taking this plea, you're waiving your right to challenge the evidence in a court of law or to present any defenses you may have had against this charge.
Yes, ma'am.
You're prepared to waive your right to go to court.
Yes, ma'am.
And you understand that you cannot go back to that motel by any means.
Yes, ma'am.
As to the charge of criminal trespass, Ms. Spikes, how do you plead?
Guilty.
I accept your guilty plea. If there's nothing further from either party, that will conclude your case, all right?
Thank you, love.
Take care. All right, who do we have next?
Next, we have position 33, Ms. Williams.
All right. All right, Ms. Williams, your case number is 22 CR 00393. I'm sorry, where did I get 3? 22 CR 0000984J, in which you're charged with battery with the offense date of February the 2nd of 2022. Do you understand your constitutional rights?
Yes.
All right, the announcement that I have is that this is a negotiated plea. Is that correct?
That is
Yes.
correct, Your Honor.
All right, Mr. Walker, the state's recommendation.
The recommendation has slightly changed. Mr. Howard was able to present some information. But with that being said, the state's recommendation now is 12 months to serve 260 days, credit for time served 130 days, balance suspended. No further contact with the victim, Karen Hargrove.
Okay. And this evaluation that was originally suggested is no longer,
That's
is no-
correct.
Okay,
That's no longer needed, Your Honor.
all right. And so how, would she have any additional time to serve at the jail?
With
No.
2-for-1, no, Your Honor.
All right, understood.
It's technically, I get, it's showing 129, I think
So we
today.
could do 258.
258, I think is how it
I'm
was.
sorry, my math isn't the best either. So 258, Your Honor, credit for 129.
Yes,
Okay, so she should not, the time, so essentially this is a time served plea.
that's
Yes,
correct.
Your Honor.
All right, Ms. Williams, you understand that the time you serve will close out your case. Do you want to take this plea today?
Yes, ma'am.
All right, Mr. Howard, do you stipulate to the factual basis, ID, and venue?
We do, Judge.
And that was your understanding of the plea. I just want to make sure.
Yes, that is my understanding, Judge.
All right, Ms. Williams, are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation of you?
Yes, ma'am.
Did anyone force or coerce you into taking a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand that you're giving up your right to go to court and present the evidence that you may have had in your favor to combat this charge, essentially. You understand that?
Yes, ma'am.
And you're prepared to waive your right to a court date.
Yes, ma'am.
All right, as to the charge of battery, how do you plead, Ms. Williams?
Guilty.
I accept your guilty plea. If there's nothing further from either party, that will conclude your case.
Thank you.
Thank you. Best of luck to you, ma'am.
Next, we have position 8, Ms. Mack.
No,
All right, position.
well, Judge, that's on one of our competency calendar cases. So I don't know if you
Okay.
want to address that now.
Oh, it's position 8 on the competency?
That's
That would require a breakout, so I don't know if we can come back to that. and
Yeah,
do
can
all-
we, let's do the breakout cases last. We haven't quite reached
Can we do,
competency.
what, can we do Ms. Cornell then? And then we do the those two last, position 11 and 8 last? And can we do Ms. Cornell?
Yeah, she's on state on purpose. All right. Good morning, Ms. Cornell.
Good
Your
morning.
case is 19 CR 0009294F, in which you're charged with 5 counts of theft by taking with the offense date of January the 11th of 2019. Do you understand your constitutional rights?
Yes, ma'am.
All right. Ms. King, is this your case?
Yes, it is, Your Honor.
What is
actually
the
wanna take
state's
this case.
recommendation?
I want to take this case, Your Honor. I'm so
Oh, okay.
sorry.
Oh, it's
PD
Mr. Walker. Okay.
Yeah, PD
Mr.
Finley just
Walker.
reached out to me, and I'm in a good mood, I guess. So the
Okay.
state's new recommendation is 12 months to serve, 30 days. Credit for time served, 15 days, balance probated, a theft class, 100 hours community service, and a stay away. I will give you that stay away location shortly, Your Honor.
All right. And it says hope for announcement. So Mr. Finley, is this negotiated at this point?
Yeah, Judge, I was just gonna ask for the community service to be taken off. Miss Cornell is 3 months pregnant. She is eager to get out. She has a medical condition that hasn't been addressed medically since she's been incarcerated. And is very concerned about that, obviously even more so as she's pregnant. So we are asking for the community service to be taken off.
You're asking for 0 community service, Mr. Finley. Okay. Mr. Walker, if you'll give me the factual basis.
Essentially, the defendant was riding around a neighborhood and they went to 5 different homes and removed mail from 5 different homes. Obviously, it had sensitive information on that mail. This very well could be a federal offense, but that's neither here nor there. The victims are very concerned because they had their mail, which has their name, their address, and other sensitive information. So the state has agreed to reduce the time from 45 days to 30 days based upon the information that PD Finley represented that she is pregnant. So I do understand. However, I think 100 hours community service based upon you basically stealing mail from 5 different locations, it isn't unreasonable whether you're pregnant or you're not pregnant. So
I'm inclined to agree, Mr. Walker. Mr. Finley, if your client takes this plea today, does she want to take this plea today in light of the decision that I made to accept the state's recommendation?
Ms. Cornell, are you still willing to move forward? So it is going to be a time served, so you would be released within 24 hours, but you are going to have the theft class and the community service. Does that sound okay with you?
Yes, that's fine.
Okay.
All right, I'm going to ask you some questions at this time, Ms. Cornell. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force or coerce you into taking this plea today?
No, ma'am.
Do you understand that by taking this plea that you're giving up your right to go to court later and challenge this?
Yes, ma'am.
And you're prepared to waive your right to a court date?
Yes, ma'am.
And you understand all the requirements of the sentence as just explained by your attorney that you have to take that class. And you also have to complete community service, but you will not have any additional time to serve at the Fulton County Jail on this charge. You understand that?
Yes, ma'am.
As to the charges of theft by taking misdemeanor, how do you plead, Ms. Cornell?
Guilty.
All right, I accept your guilty plea at this time. I believe that will conclude your case if there's nothing further from either party.
Your Honor, I'm sorry, I do have that stay away location. It is
Yes.
639 Greencrest Lane.
So is there more, are there 5 stay away
It is,
addresses?
they are all on the same block, so we'll just put 639.
Stay away from
Yeah.
Greencrest Lane.
I don't
and
have
it's
all
a
the
turn.
addresses, but they were all neighbors on the same street. So I think 200 yards from 639 Greencrest Lane should cover our base.
All right, so you must stay away from Greencrest Lane in its entirety. Oh, Mr. Finley, were you gonna object?
Oh, no, I wasn't gonna object. I was just gonna say if we could waive the probation fees for a period of time as well.
No objection, Your Honor.
All right, the theft, how long is the theft class?
It's 1 day.
It's a 1 day? Okay, I'll wait 3 months as well in light of her medical condition. All right, best of luck to you, ma'am.
Thank you.
All right.
Thank you.
No, that's not. Ms. Cornwell is. You have add-on, with add-on, 11, Ms. Satterwhite.
Did we have an add-on calendar today?
I don't
I'm
have
sorry.
an add-on calendar.
No,
She's on the competency calendar.
Okay, we'll hold for her.
Okay, we're gonna hold just before we go into that set of breakouts. Have we completed everyone at South Annex who's on the state all purpose?
yes, no, just hold on, you're okay. Yes, Ms. Maddox, Judge, there's just these 2 I have left. Ms. Mack and Ms. Satterwhite.
And they're on our competency calendar.
Yes.
All right. At courtroom 2, were we ever able to get we may have to go to the competency calendar if we're unable to get the defendants who were, I believe we were holding for position 18 to come forward. All right, we may just pivot to the competency calendar in the interest of time if there are no other positions that we can take. Oh, I see 3 South. Who do we have at 3 South?
Got position 34.
And Mr. McLean needs to speak with position 34. Is that correct, Mr. McLean? You need to speak with Mr. Ricky Williams?
Correct. My cell phone on which I have the Zoom session going and can unmute is rapidly losing power. So I better talk to him quickly.
Okay. Is it possible, Mr. McLean, that perhaps you step outside or somewhere?
It would take less, if I got off of Zoom, it would take less power if they just had him call me on my phone.
Can someone at 3 South give Mr. McLean a call on his cell phone?
He called the cell phone and he did not.
770-842-5471.
Called in 2 times, McLean. No answer.
Someone, they're trying to reach you now, he said, and no, he's gonna step out right now, and then they're gonna, if you would give him a call now, Mr. McLean will speak with, I think because he's in the Zoom conference, he wasn't able to see that call, but he's gonna end the Zoom, and he's gonna step out right now to speak to Mr. Williams.
Position 5.
All right. And in the meantime, we're going to, Mr. Finley, you do have position 5, correct?
Yes, Judge.
All right, so we can go to Shannon Boswell. Mr. Boswell, your case number is 22 CR 003872E, and what you're charged with 1 count of battery and 1 count of affray with the offense date of June the 17th of 2022. You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney at this proceeding. Do you understand your constitutional rights?
Yes.
All right. The announcement that I have is that this is a negotiated plea.
That's correct.
Whose case is this for the state? Is it you, Ms. Backus?
No,
Or is
it's
it
the
Ms.
one that came
King?
for the state, Your Honor.
All right, Ms. King, what is the state's recommendation?
It is for the battery, 12 months to serve 16 days, credit for time served 8 days with the balance probated, an 8-week anger management course, a stay away from the West End MARTA Station, 680 Lee Street, Southwest in Atlanta, and no further contact with the victim, Mr. Michael Dubose. Michael, traditional spelling, Dubose, Dubose, and the affray will be no pros.
Okay, so will you please send the no price order as soon as you can, Ms. King? Was that your understanding, Mr. Finley, of the recommendation?
That is our understanding, Judge. We're just going to ask that once Mr. Boswell does complete that anger management, that the balance of his probation to be non-reporting.
No objection, Your Honor.
No objection to the non-reporting. Can I have his history? Ms. King, do you have it? Most interested in prior batteries.
No, Your Honor, there's nothing violent on his criminal history.
Okay, all right, then I'll allow it to go non-reporting at that time. Mr. Boswell, I'm gonna ask you a series of questions as well to make sure you're voluntarily taking a plea today, okay?
Yes, ma'am.
Are you under the influence of any drugs or alcohol at this time?
You said what?
Are you under the influence of any drugs or alcohol at this time?
No.
Are you satisfied with your attorney's representation?
Yes.
Did anyone force or coerce you into taking this plea today?
No.
Do you understand that by taking this plea, you're waiving your right to challenge the evidence in a court of law, and you're essentially giving up your right to challenge this in its entirety?
Yes.
And you're willing to waive your right to go to court later and challenge the state's charges against you?
Yes.
And has anyone offered you any gifts or anything in exchange for taking a plea today?
No.
As to the charge I previously listed, Mr. Boswell, how do you plead?
Guilty.
And you do understand that you cannot go back to the West End MARTA station or have any further contact with Michael Dubose. You understand that?
Yes.
All right, I accept your guilty plea at this time. If there's nothing further from either party, that will conclude Mr. Boswell's case.
Thank you, Judge.
All right, best of luck to you. All right, okay, I see position 3 has been loaned out. We're holding on, what about position 8? All right, who do we have at 3, Seth?
Oh, wow, yeah.
For you is Miss Satterwhite, position 11 on the competency calendar.
All right, we're not quite yet ready for competency.
Okay.
We'll come right back to that. Who is who do I have at 3 South?
Position 34.
All right, we're ready for position 34. Mr. McLean?
Yes, Your Honor, I am signing on his behalf as he just asked me to, and I quickly went over the plea statement, which if it were oral would be referred to as the plea colloquy, but he understands his rights and wants me to sign his name to a guilty plea on his behalf, which I am doing right now.
All right, the court doesn't love that, but I understand in light of we still have virtual, we'll allow that to go forward today. Mr. Williams, your case is 22 CR 00402AJ. I will not sound this charge with the offense date of October the 20th of 2021. Do you understand your constitutional rights? You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney. Do you understand those rights?
Yes.
All right, thank you. Let's see, Ms. Backus, is this your case?
This is my case, Your Honor. And so I had it written down. Well, actually, I had it in an announcement. And so we're doing a non-negotiated plea.
My announcement, it says hold for announcement. Is this negotiated or non-negotiated, Mr. McLean?
Number 34, Ricky Williams.
Yes, Mr. Williams.
And I've had on my.
The state's offer is, what is the state's offer?
The state's offer was 12 months to serve 365 days, credit for time served 255 days.
Right, that would amount to a simple time served plea.
So that, okay. If he, assuming he gets credit for the 2-for-1, he would not have any additional jail time to serve, correct?
Correct.
All right, and that was your understanding of the offer, Mr. McLean?
Yes.
And you stipulate to the factual basis, identity, and venue?
We do.
All right. Mr. Williams, you understand that this essentially is a time served plea and that your time served in the Fulton County Jail will close out your case?
Yes, ma'am.
Would you like to take this plea today?
Yes, ma'am.
All right. I'm gonna ask you a series of questions to make sure that you're knowing and voluntarily taking this plea, all right? Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force or coerce you into taking this plea today?
No, ma'am.
Do you understand that by taking this plea, you're giving up your right to a court date and to force the state to prove the charges against you beyond a reasonable doubt?
Yes, ma'am.
And are you prepared to waive your rights to a court date?
Yes, ma'am.
I'm sorry, you are? And you, all right, as to the charge that I will not sound, but you're aware of through your attorney, how do you plead, Mr. Williams?
Guilty.
I accept your guilty plea. If there's nothing further from either party, that will conclude your case. All right?
Okay, thank you, Your Honor.
Thank you. All right, who do we have next?
Next, we're gonna have position 32.
All right.
Wilcox.
All right, Mr. Wilcox, the announcement I have is this is a negotiated plea.
Correct, Your Honor. It's simply a time served, balance suspended, stay away from location.
All right, Mr. Wilcox, your case is 22 CR 003845C, in which you're charged with criminal trespass. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding. Do you understand those rights?
Yeah.
All right, Ms. Backus?
Yes,
Is
Your
this your
Honor.
case?
Yes, Your Honor. The offer, is that what you're asking for with the offer?
Yes, put your offer onto the record.
On the record, time served 16 days, balance suspended. Stay away from the incident location, which is 932 Lee Street Southwest. And it looks like that is a store.
All right. And Ms. McLean, that was your understanding, and you stipulate to factual basis, ID, and venue?
We do. It is in fact a gas station, Chevron brand.
All right, Mr. Wilcox, the time you serve will close your case, but you cannot go back to that gas station under any circumstances. Do you understand that?
Yes.
All right. Are you under the influence of any drugs or alcohol at this time?
No.
Are you satisfied with your attorney's representation?
Yes.
Did anyone force or coerce you into taking this plea today?
No.
Do you understand that by taking this plea, you're giving up your right to a court date and to have the state prove these charges against you beyond a reasonable doubt?
Yeah.
And you're prepared to waive those rights?
Yeah.
And you understand that you can't go back to that gas station, even though I explained it. I'm saying it again to make it clear. You understand that?
Yeah.
As to the charge of criminal trespass, Mr. Wilcox, how do you plead?
Yes.
I accept your guilty plea, and I believe that will conclude your case if there's nothing further from either party.
Further, Your Honor.
All right, best of luck to you, sir. Don't go back to that gas station, all right?
All right.
Thank you.
All
right. Who do we have next?
22. 22.
22 is Mr. Lucina.
All right, Mr. Lucina, your case number is 22 CR 003894B, on which you're charged with obstruction of a law enforcement officer and giving a false name or birth date to a law enforcement officer with the offense date of June the 17th of 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right. And I'm not sure that you heard them. You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney. Ms. Backus, will you please put onto the record the state's plea offer?
Yes, Your Honor. The state's offer is 12 months, serve 30 days, credit for time served 15 days, and balance suspended.
So the time you serve, Mr. Lucina, will close out your case. And there shouldn't be any further conditions on you. Do you want to take this plea today?
Yes, ma'am. I have another question too, Ms. Bill. I posted cash bond for 2,500.
I'm unable to hear you, Mr. Lucina, and I want you to be careful about what you're saying to me because the state is listening. What is your question?
Your Honor, I believe he's going to ask you a bond question, which I explained to him will be irrelevant at this point.
Right. This will close the case, and this case will no longer be holding you in the Fulton County Jail. All right.
I understand that, but y'all not listening to what I'm saying. All right, whatever. All right.
No, I mean, ask your question, but very briefly. Go ahead.
I'm saying I had posted a cash bond. Will that be returned to me?
He's asking whether the cash bond that he put
Oh,
up
I can't
will
speak
be
to that. I
returned
can't,
to him.
right, I can't speak to that, Ms. Lucina. I'm unaware of whether or not the cash fund that you paid will be returned to you. All right? Do you still want to take the plea?
So the days is, I'm getting time served already credited right now, so I don't have to do no more days, just wait on the extradition.
Yes, you should not have to serve any more time at the Fulton County Jail. This case will not be holding you in, all right? Do you want to move forward and take the plea today?
Yes, ma'am.
All right, are you under the influence of any drugs or alcohol at this time? Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force or coerce you into taking this plea?
No, ma'am.
Are you prepared to give up your right to a court date and have the state prove these charges against you beyond a reasonable doubt?
Yeah.
If you take a plea, you don't get a court date. You understand that?
Yeah, I get it. I understand.
I can't hear you. I'm sorry.
Said, yes, I understand.
Okay, thank you. And you're prepared to waive your right to a court date?
Yeah.
All right. As to the charges previously listed, Mr. Lucina, how do you plead?
Guilty.
I accept your guilty plea. As I said, the time served will close out the case. If you don't have other holds, you should be released from the Fulton County Jail shortly. All right.
Thank you, ma'am.
All right. Take care. Best of luck to you. Are we complete at 3 South?
Yeah, we done on 3 South. I'm heading upstairs to 4 North and 4 South. So give me about 5 minutes.
I'm sorry, I can't hear you. The phone was going in and out.
He said 4 North and 4 South in about 5 minutes.
Okay, 4 North and 4 South. How many are we holding on other?
Judge, position 15, he on quarantine. That's a game. He on quarantine right now.
Okay, so that'll have to be a medical reset. We were also holding on position 18. Is there an announcement for 18?
Judge, I'll just go ahead and make it. Given that Mr. McLean was not able to speak with him on last evening, that we're going to need to reset him to Tuesday's calendar so we have an opportunity to meet with him.
Well, if they could get him today and Mr. McLean could speak to him while we're doing the competency, Mr. Howard, I would prefer, if at all possible. If it's not possible, I mean, I'm happy to do the reset, but our calendars just get longer and longer as we continue to reset, and that's what I'm trying to avoid, if at all possible. Can we commence the competency calendar? I know we'll have to go into a breakout while we wait for the announcements on position 18. And again, I will reset it if they're unable to get.
And Judge, I'm going to ask you to do that because I understand the court's position, but we need to sit down and go over the paperwork and we can't have a 5-minute conversation. Won't resolve that issue. So we ask that it be reset to Tuesday.
Right. That involves more than just the time served. Right.
All right. Then we'll reserve that judgment. All right, we'll go to the competency calendar. Can I be placed into a breakout room with Mr. Walker, Mr. Howard? And who else needs to be in this breakout room with me?
Ms. Kasha Williams as well, Judge.
All right.
And Judge, I just want to confirm we are still waiting on a couple more from the SAP, right?
I believe so. Ms.
Okay.
Middlebrooks, did we do the entire SAP calendar?
I think I have 2 more.
I see 3 or 4. I'm just trying to move us along.
Understood. No, understood. I just wanted to double check.
No, we're not complete on SAP, but rather than sitting there, let's do the work that's ahead of us if possible.
Yes,
all
ma'am.
right.
Understood.
Hopefully, courtroom 2 can bring the other defendants. All right, if I could be placed in that breakout room with Ms. All right, who do I have at 4 North? Can 4 North hear me? Is 4 North frozen? No, 4 North is not frozen. Who do I have at 4 North?
All right, we got position 8.
Position 8. All right, are you Aaron Coker?
Yes, ma'am.
Mr. Coker, your case is 22 CR 0038748. And what you're charged with 1 count of theft by taking with the offense date of February the 15th of 2022. Do you understand your constitutional rights?
Yes, ma'am.
I'm gonna state them just in case I'm not sure you heard them. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney at this proceeding. Ms. King, will you put the state's recommendation onto the record?
Yes, Your Honor. The state's recommendation for theft by taking, 12 months to serve, 123 days, credit for time served, 123 days, with the balance probated, restitution to Best Buy in the amount of $554, and a stay away from the Best Buy location located at 2537 Piedmont Road.
All right. And was that your understanding, Mr. Finley?
Yes, Judge, that is our understanding. And Mr. Hooker has agreed to pay the restitution. Was just going to ask that once he does pay that restitution, as that's the only condition on here, if the balance of his probation could be terminated. But if you're not inclined, Your Honor, non-reporting.
All right. Let's see. What was the item that was taken?
It was multiple items, Your Honor. It was an Amazon Fire TV stick, a Roku streaming stick, a Roku Express device, Fire TV Cube, and a Fire TV Cube. And it was 4 Amazon Fire TV sticks and 3 Fire TV Cubes.
All right. It can go non-reporting once he's paid the restitution, but he will be on probation the entire year. All right. Does your client still want to take this plea? He does. And do you stipulate to the factual basis, ID, and venue, Mr. Finley?
Yes, Judge.
All right, Mr. Coker, I'm going to ask you some questions to make sure that this is a voluntary plea, all right? Are you under the influence of any drugs or alcohol at this time? I'm sorry, I can't hear you. I need you to speak up. Are you under the influence of any drugs or alcohol?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force or coerce you into taking this plea today?
No, ma'am.
Do you understand that by taking this plea, you waive your right to challenge the evidence in the court of law and the right to have a court date where you might be able to present your own facts and evidence?
Yes, ma'am.
And you're prepared to waive your right to go to court?
Yes, ma'am.
And you understand the requirements of this sentence that you have to pay restitution to Best Buy and you'll be on probation for a year. You understand that? As to the charge of theft by taking, Mr. Coker, how do you plead? I accept your guilty plea, and if there's nothing further from either party, that will conclude your case. All right, best of luck to you, sir.
Okay, next we got number 26, Mr. Reese.
That's my case, Your Honor.
All right, the announcement I have is that this is a negotiated plea as well.
Simply
That's
time
correct.
served, Your Honor, yes.
All right, Mr. Reese, your case number is 21 CR 003417G. I'm not going to sound the charge here. With the offense date of September the 12th of 2019. You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney at this proceeding. Do you understand your constitutional rights?
Yes.
All right, Ms. Backus.
Yes, Your Honor.
Will you
The state's-
Yes,
The
thank you.
state's offer the state's offer on this one is time served 50 days.
All right, and Mr. McLean, that was your understanding of the offer?
It is.
And do you stipulate to the factual basis, ID, and venue?
We do.
All right, so Mr. Reese, the time you served in the jail will close your case out. Do you want to take a plea today?
Yes.
All right, are you under the influence of any drugs or alcohol?
No.
Are you satisfied with your attorney's representation?
Yes.
Hold on. Did anyone force or coerce you into taking this plea today?
No.
Did anyone offer you anything in exchange for taking a plea?
No.
And you understand that by taking a plea today, you're giving up your right to go to court to challenge charges against you?
Yes.
And you're prepared to waive your right to go to court?
Yes.
All right, as to the charge that I did not sound, but I'm sure that you're aware of through your attorney, how do you plead, Mr. Reese?
Yes.
I accept your guilty plea at this time. Is there anything further from either party?
No, Your Honor.
Further, Your Honor.
All right, that concludes your, this matter, Mr. Reese. Best of luck to you. All right, is there anyone else at 4 North?
No, ma'am.
All right, does that complete the SAP calendar as far as the announcements we have? Is there an announcement for position 9?
That's the one I was just going to ask.
Mr. Cole, I believe.
Yeah,
He's on the quarantine as well.
All right, so that will be a medical reset to Tuesday. All right. Are there other, position 18, we're gonna reset as well. I'm assuming we were able to get them. Position 3 says loan out to the county. I don't believe position 3 is available. Is that correct for position 3?
Yes, yeah. Yesterday when I went to the jail, they said it said loan out county in quotes, and he wasn't there. That's what they said.
Okay, so I'm assuming position 3 can't be brought today. Ms. Middlebrooks, who else are we holding for? All right, so I believe that all right, so that concludes the SAP calendar. Let's move to the competency calendar at 11 o'clock. All right, and I believe there are some positions on the competency calendar at the South Annex. Do we want to review the SAP calendar before I do that?
Please, Your Honor.
All right. All right, Ms. Middlebrooks, will you please review for me?
Judge, this is a court reporter. Since you're doing competency, may I be excused?
Yes, you may. No, please will be taken at competency. Well, we may need you for the DV reset calendar.
Okay. All right.
So
I'll stay on.
Please hold.
Okay.
Okay, position number 1 was a plea. Position number 2 was a reign. There's a bond modification of $1,000 good bond. He's reset to the SAP for 7/7. Position number 3, reset to the SAP for July 5th. Position number 4 was a plea. Position number 5 was a plea. Position number 6 was a plea. Position number 7 was release. Position number 8 was a plea. Position 9 has been reset to the SAP July 5th. Position 10 is a plea. 11 was a plea. 12 was a plea. Positions 13 and 14 were released. Position 15 is reset to the SAP July 5th. Position 16 was released. Position 17 was arraigned, reset jail jury. Position 18 has been reset to the state all-purpose July 5th. Position 19 was arraigned, reset to the state all-purpose July 7th. There's a bond modification for a $4,000 good bond. Position 20 was a plea. Position 21 was a plea. Position 22 was a plea. Position 23 and 24 have been reset to the state all-purpose July 7th. Position 25 was a plea.
Position 26 was a plea. Position 27 was a plea. Position 28 has been reset to jail jury. There's a bond modification for $5,750 good bond. Position 29 was a plea. Position 30, 31, and 32 were pleas. Position 33 and 34 were pleas.
Not yet, not yet. We still gotta do competent decisions. Any comments, changes, corrections, or questions?
Small detail, number 19, the bond reduction I had down was count 1, 2,000 reduced to 1,500, and count 2, 4,000 reduced to.
I'm sorry, which position, Mr. McLean?
Number 19, I just need the absolute total there.
I have $500 on count 1 and 3,500 on count 2, totaling the 4,000 surety.
Yes, that's what I have as well.
Thank you. That corrects my mistake. I was off by 1,000. Thank you.
All right. That concludes state all purpose. Let's move to the competency calendar, then we'll take up the DV bench warrant reset calendar. All right. We have positions at South Annex that appear on this competency calendar. I'd like to take Miss Felicia Mack last, if she's there.
Yes, that's fine.
And just real quick, Judge,
That's okay,
I don't.
because this is public, we're not, yeah. I'm sorry, go ahead.
Yes, ma'am. There's a DV calendar? I did not get a DV calendar.
There is a DV reset calendar with 2 positions.
And I think one of them is a private attorney. And the non-private attorney, I actually was going to be willing to agree to the set aside. There is a small concern I would like to address. But on the case that there is not an attorney, I think that we'll be able to resolve that this morning.
I want to see if we can resolve both, to be honest. If I'd like to take.
I can't make any promises, Your Honor.
I know you can't make any promises, but I'd like you to try. That's
Yes,
all I'd
ma'am.
ask. All right, the competency calendar, we should be able to get through quickly. So let's try to jump in and do that very quickly. Mr. Walker, you're handling the DV reset calendar yourself, so you can't really step aside to speak to anyone right now either.
That is correct, Your Honor.
Okay, man of many talents. All right, so we'll just keep going. Who do I have at South Annex who's on the DV calendar?
It's Satterwhite, position 11, and Ms. Mack, position 8.
Excuse me, Judge. This is JCS probation. Do you need me or do y'all need me?
I don't believe we do.
Okay.
No.
I don't think
You're free to go.
Okay, well, y'all have a good one.
You too. All right, I'll take Ms. Satterwhite first. Ms. Satterwhite, I'm just gonna inform you, your case number is 22 CR 002675E, in which you're charged with criminal trespass. With the offense date of March the 14th of 2022. I spoke with your attorney, and your attorney will speak with you following this hearing. You're gonna undergo some evaluations, and they're working on setting a plan up for you. Your case is gonna be reset, all right? I just wanted to make you aware of that today. Your case will not be resolved at this time. Do you understand that, Ms. Satterwhite?
Yes.
All right, Mr. Howard will reach out to you and he will discuss this plan with you further, all right?
Okay.
All right.
Thank you.
That concludes your case, all right. All right, Ms. Mack.
Judge, can we do a breakout with her, with the parties? Because I see other people on the call that don't.
Yes, that's fine. If we could be placed in a breakout, the rest of the South Annex will still hear, but.
Right. I think it's on person.
All right, if we could, I'd be placed in a breakout with Mr. Howard, Mr. Walker, and South Annex. That would be great.
And Ms. Akasha as well.
Oh, yes, Ms. Kasha as well. South Annex was asking to be excused. I believe South Annex can be excused. South Annex can be excused. Take care. Have a great afternoon. Ms. Middlebrooks, will you review the competency calendar for me?
Position number 1 will be reset to the July 14th calendar. Position number 2, reset to July 28th. Position number 3, reset to August 11th. Position number 4, reset to August 11th. Position number 5 was no cross. Position number 6, reset to July 21st. Position number 7, reset to July 14th. Position number 8, reset to July 14th. Position number 9 is a transport order for July 6th. Position number 10, reset July 21st. Position number 11, reset August 4th.
Any comments, changes, corrections, or questions? All right. Oh, I didn't sign it yet. All right.
Judge,
Hearing
if I
none.
could,
Yes.
we would reset Ms. Position 9 to the 7 just to make sure she gets transported.
Okay, that makes sense. We'll reset the 7th to make sure that she gets that transport for next Wednesday.
Yes, thank you.
And I need to sign that signature bond as well.
Yes.
All right. All right, Mr. Walker, you had some announcements and discussions regarding the DV reset case for Mr. Pate. You said Mr. Pate is the one that you believe.
Position 2. The state is prepared to set aside the bench warrant. There was one concern. Typically, when we have these type of matters, there's an address change form and a set aside form that's filled out and uploaded into Odyssey. I did not see that on Odyssey. So I just want to inquire that we do in fact have a good address, since we don't have that standard paperwork that's typically uploaded for these type of matters.
And that's Mr. Pate. Mr. Jarvis Pate, are you present on the Zoom conference?
Yes, I am. Yes.
Okay, is it, Mr. Pate, do you have an attorney? You are unrepresented.
No,
Yeah.
no, I'm still in the process.
Mr. Finley, were you willing to assist him? Does he qualify for the services of the Public Defender's Office?
Yes, Judge, I am willing to represent him today. He said this past week he did get an application for the Public Defender's Office. So he's yet to hear back, but I'm okay representing him today.
But I don't know if Mr. Finley can help him fill out that address change form, but as long as we get that form, the state will consent to the
Is there currently an offer for his case, Mr. Walker, at this point?
There is an offer. Give me one.
And well, let me read him as right. Mr. Pate, your case is 20 CR 003377F, in which you're charged with simple battery family violence with the offense date of May the 14th of 2020. The state has indicated that they are willing to set aside the bench warrant that's out for you at this time. And it appears that there may be an offer on the table. What I'm going to ask that you do is speak with Mr. Finley, who's available on this Zoom conference and is willing to assist you regarding that offer, in the hopes that we might be able to just resolve and close your case today, okay?
I'll put that offer
Yes,
in the chat to Mr. Finley.
Judge, if I might, if there's a plea offer involved, we need time. We're not prepared to deal with the plea today. We don't even know if he qualifies. But even if he does, we don't have any information about his case, no discovery. We're not prepared to do a plea today. But we can certainly, follow up at a later time if that is something, if he wants our representation. Now, obviously, he can proceed pro se and do whatever he chooses. But for our purposes, Judge, we need time in order to meet our ethical duty of diligence under the bar rules.
I understand.
Before we can do that.
Mr. Howard, he can't even hear you're not willing to even allow.
I mean, he can hear it, Judge. I just want to set the court's expectation about our involvement.
You have to understand in the interest of judicial economy, we are all here today, Mr. Howard. I do understand the need for zealous advocacy and a thorough and adequate defense. But if Mr. Walker were to offer him something that, we just couldn't all refuse. And I'm not saying that Mr. Walker will do so, but I'm just asking that we at least hear Mr. Walker's plea offer.
The offer for today and only for today is if he would like to take a guilty plea as charged, it will be time served, balance probated, a domestic violence intervention program, and no further violent contact with the victim. There is a one-day offer. Obviously, he does not have to take it, but I do not think the offer could get any better than that. So basically the FFIP course and no further violent contact, Your Honor.
Mr. Howard, do you renew your objection to him taking the plea today?
Well, Judge, again, if he chooses to take a plea today, he would need to do it on his own without the assistance of the public defender. We couldn't represent him for purposes of a plea today, but I understand if he decides that's what he wants to do, he's heard the offer, he can do that. But if he'd like,
I understand the public defender's office is not one to accept to represent him if he takes that plea. Mr. Pate, you understand your rights at this time, and you have a right to an attorney. Apparently, the public defender's office will not be able to assist you if you wish to take a plea. What the state has offered you essentially, and I am not at liberty to give you legal advice here on this Zoom conference. I'm not operating in the capacity of an attorney today. How long is that course, Mr. Walker?
It is 24 weeks, Your Honor, one time a week.
Okay, that is it's quite a long course. You would have to pay for that course yourself, but essentially you would have to have no further violent contact with the alleged victim. Mr. Walker, can I please hear the factual basis here? That is going to play a part to see if I'm even gonna.
Give me 1 second.
All right.
So on May 14th of 2020, APD responded to 180 Howell Drive. They spoke to the victim, whose name is Miss Bionica Watts, who responded that her significant other, the defendant, and her got into a heated argument. At that time, he did push her onto the bed. He grabbed her by the leg and threw her around the bedroom. She advised that after this ended, the children in the home became concerned and began to bang on the door and plead for help. At that time, 911 was called and police were dispatched.
All right, is this Ms. Watts? Are you the one in the courtroom? Ms. Watts, if you'd like to make a statement, please come to the podium. All right, I'm gonna swear you in, Ms. Watts. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
What would you like to tell the court at this time?
That since the incident, me and Jarvis have a 6-year-old daughter together. And since really the incident, Jarvis hasn't seen his child since then. And that's going on almost 2 years. Maybe he's seen her once, but because of this case is going on, I don't feel that Jarvis is a bad person. We had an altercation and that was that. And it's been almost 2 years and we haven't had any contact at all with each other on violence or anything. But this case is really making it hard for him to be a parent to my child.
All right, thank you. I appreciate you making that statement, Ms. Watts. Mr. Pate, you have several options here today. The state is willing to set aside the bench warrant against you upon receiving the information that you had the wrong address in the file, and the case would proceed forward, or you could accept this offer pro se. The problem with you accepting an offer pro se is there's no one to assist you with the paperwork. Are you located in the Atlanta area?
Not at the moment.
The problem is you would have to get to a place where you could fill out plea paperwork, take said offer, and send it back to me. You also have the right to delay this procedure and speak to an attorney regarding whether or not this is a deal you should take. So the ball really is in your court. Mr. Howard has indicated that the public defender's office will not assist you with a plea at this time, but that doesn't mean you can't speak to Mr. Finling just in general about a good course of action, which is what I'm going to suggest that you do. They will not assist you with any aspect of a plea. Mr. Howard has made that clear, but he can give you some temporary guidance. Would you like to speak to Mr. Finling?
Yes.
Okay. If Mr. Finling and Mr. Pate could be put into a breakout, and then Mr. Pate will come back with an announcement for the court for what he would like to do. All right.
And if Mr. Howard could be in there as well.
Oh, Mr. Howard as well, of course. All right, let's move to the case of Miranda Kelsey Holcomb, case number 17 CR 004839F, in which the defendant is charged with following too closely, hit and run, and false report of a crime. Mr. Walker, I believe, I see an attorney, Jamie Steinhaus. Do you represent Ms. Holcomb, Ms.
Yes,
Steinhaus?
Your Honor.
All right. Mr. Walker, there's currently a bench warrant out for Ms. Holcomb. What is the state's position regarding the bench warrant, and is there currently an offer on this file as well to resolve that case today?
There is currently an offer, and there also is a bench warrant. I believe that the bench warrant is for the amount of $11,000. I do not believe that's a reasonable amount, but the state's position is that the defendant is remanded into custody and post a new bond in the amount of $1,000 surety bond on each count. I believe that's a $3,000 surety bond. And the state's reasoning for that is because this defendant has FTA'd 3 times. She has made bond twice, and she has previously had another bench warrant set aside. So going back to 2017, she had a plea arraignment that she FTA'd at, a bench warrant was issued. December of that year, she was picked up. She made a new bond. Her next plea arraignment was in May of 2019. There was another FTA, which a bench warrant was issued. That bench warrant was set aside in the year of 2020. And then most recently, she had a status hearing, I believe, in front of Judge Law on March 4th of this year, which was another FTA. So again, she's made bond twice. The state has set aside one of her previous bench warrants. And at this point, I'm in no other position but to ask that she's remanded into custody and post a $3,000 surety total bond. If she would like to resolve, if she would like to resolve the plea or resolve the case, it would be a $500 fine on each count.
Okay.
And of course, early termination upon completion of payment.
I'm sorry, Mr. Walker, say that the last
Early termination upon completion of payment.
of the payment. Ms. Steinhaus, I just have to ask, what is your client's position regarding these FTAs and this particular failure to appear?
Yes, Your Honor. It is our understanding, Kevin Fisher and I are both representing Ms. Holcomb on this case, that the timeline was as follows: that she was arrested in February of 2015. At that time, she was living in Roswell, Georgia. She then moved to Rome within, I believe it was about a year and a half afterwards. She believed that her mail was being forwarded to her new address in Rome, was unaware of the address change process within Fulton County. At that point, her case was accused and put on a calendar for arraignment. She then had a warrant for the FTA. She then moved to Dalton, Georgia in 2018. And at that point with the FTA, she was aware that she needed to file an address change. She did do that. We have spoken at length regarding the address change that she sent in. She does not have proof that she sent that in. But that is my client's basis on that. And that in 2019, she again updated her address to another address in Dalton, Georgia. Both times she was arrested on the FTAs. Both times she served, I believe, upwards of 3 days. So she served a total of 6 days at this point on both of those FTAs. And at this point, we have updated her address with the clerk's office. We were retained last week when she was made aware that she had another FTA. And at that point, we updated everything with the clerk's office. We connected with, I believe, Beverly Johnson, who I believe is on for the SAP calendar. And we're trying to resolve this matter as quickly as possible for Ms. Holcomb. Ultimately, it was a lot of moving. She's moved almost every single year. She said that she had updated the court at least 2 times on the address change, and apparently that was not done. But ultimately, it was a lack of awareness. It was not a purposeful evasion of court. And we would ask that there would be no more time spent in jail on this matter.
I'm going to ask, would you like to speak with your client regarding the offer made by the state today?
So I have not received discovery or anything on this. I believe we have an accusation that I picked up in the clerk's office last week. But my understanding of the offer, Mr. Walker, and correct me if I'm wrong, is $500 fine on each one of the counts. And so that would just be a guilty plea on each one.
That would be correct, and I'll actually modify that. I will allow the following too closely to merge into the hit and run.
Okay.
So I think the following too closely is count one. We'll allow that to merge into the hit and run. It will be then a total of $1,000 fine, which will be for the hit and run and false report of a crime. So it will be $500 fines on each of those counts. And yes, ma'am, it would be for a guilty plea with no additional jail time. And like I said, probation could terminate upon completion of the payment.
Okay.
Now, would you like to speak with your client, Ms.
Yes,
Steiner?
please.
All right. Can you call her separately, or do you need to be put in a breakout in this Zoom conference?
I can call her.
Okay.
Thank you.
All right, we'll be on hold while you speak with your client.
Okay.
Brief recess.
Thank you.
All right, is there an announcement on Mr. Pate's case?
Judge, Mr. Pate would like an opportunity. We've spoken with him. He wants to speak with Mr. Walker. And depending on that conversation, it'll determine kind of.
Okay, so Mr. Walker needs to go into a breakout with Mr. Pate.
Yes.
Mr. Jordan, if you could put Mr. Walker and Mr. Pate in a breakout. Mr. Walker, I'm assuming that you're willing to go into said breakout.
Of course, Your Honor.
Okay. Oh, Mr. Pate is not on the line? Oh, that's unfortunate.
He might have clicked leave room.
The wrong thing.
He stayed in the breakout room, Your Honor. I just added Mr. Walker in with him.
Oh, thank you. I thought Mr. Jordan was with me. I apologize. How are you this morning?
I'm good, Judge. How are you?
I'm well. I'm not good at maintaining your stacks either, so I'm just gonna, I tried. Will you check and make sure I didn't miss any pages?
I'll be back in 2 seconds. I'm gonna run upstairs and get those forms.
Come down. I gotta see you on the screen. Why you on my phone?
Drill sergeant, at least, you know what, I just. Mr. Walker, is there an announcement?
There is an announcement. Unfortunately, there is not a resolution.
All right, the
not
state
take the
will.
offer, but we will rescind it further notice, and I verified his address, so it'll be.
All right, we'll set aside the bench warrant at this time. The case will be reset for the notice bond conditions will remain as such. All right, that concludes Mr. Pate's case. I understand the position of the public defender's office. I do, but I am disappointed we were not able to resolve this today. Mr. Pate, you're waving your hand. You had a question?
Yeah, I'm sorry. I'm willing to take that deal. I'm tired of dealing with this.
Okay.
I just had to change the heart. I'm tired of dealing with it.
Okay.
The state can email the paperwork. I'm not sure how we can.
I don't really know how we're gonna, to be honest, Mr. Pate, I don't know how you're not in the Atlanta area. You would, it appear, are you in an 18-wheeler?
No, I'm in my work truck. I'm currently in Rome, but I'll be heading back to Atlanta within the next hour or two.
The problem is typically pleas can be taken at this calendar, but if you weren't present or near a Kinko's, or does Kinko's even exist, something where you could print this out, a library, and get this paperwork to me, and you have to do it by the conclusion of this calendar.
I'm not sure if the court would oblige, but if we reset it to next Thursday and he comes into courtroom G33.
Yeah, I don't have an objection. You'll still send me his paperwork to set aside his bench warrant. We will reset this to the DV reset calendar. This will give you time to engage more with the public defender's office, Mr. Pate, and I'll reset your case 1 week. All right. But for right now, there will not be a bench warrant. And instead of resetting it to further notice to a division judge, we'll reset it to next week. Okay.
And if I could just confirm his email address, is it crispy13@gmail.com?
Yes.
Okay, well, I will pre-fill out that paperwork and email that to you. And then as the judge stated, we're going to reset this to next week, and you can fill that out and email it back to me, and we can take that plea next Thursday.
All right.
And in the meantime, still engage with the public defender's office. It seems like you had some issues and concerns. You have a good 7 days to still stay engaged with them and to get information that you may need. All right. Your case will be so reset to next week. And Mr. Walker, if there is any relevant discovery that you do have that might assist the public defender's office in resolving this case by next week, it would be greatly appreciated if you would send that over.
I believe it might have already been sent over, but if not, I can certainly send over what I have.
Send it again. We would love to not have this be outstanding next week. All right.
I agree. Yes, ma'am.
All right. Thank you.
Judge, right. In our discussions with him and getting some income information, things we needed, he wouldn't qualify for our services anyway, Judge. So,
okay. So Mr. Pate, in light of that information, you have a week to speak with private counsel. You're not going to qualify for the services of the public defender's office, even though they were willing to assist you today. Okay. So what I suggest you do is at least pay for an initial consultation with an attorney. So someone who could speak with you regarding this, letting them know that you have a potential plea offer and your case will be so reset to next Thursday. All right.
All right.
Do you want to speak to someone who can give you the best advice? And you have a week to do so. Please move expeditiously. I don't want them. Judge Law, I believe, will be presiding next Thursday, and I would love for her to not have to deal with this same situation. All right.
Since the PD's office won't be representing him, when I send over the paperwork, I will send the discovery to Mr. Pate himself.
Okay, so Mr. Pate, what that means is the information that you need, that any attorney will need to represent you, you're going to have it directly. So when you go for that initial consultation, please take all of the information that Mr. Walker is giving to you. All right?
Okay.
All right, so you have 1 week to try to get some guidance regarding this case, and we will see you back here next Thursday at 11. All right?
All right, thank you.
All right, take care, Mr. Pate. Ma'am, his case is going to be reset to next Thursday. You are welcome to come again, but it probably will be just like what happened today. All right. There's nothing I could do to resolve it at this time.
I won't get in trouble if I don't come.
No, you will not. You're not required to be here. All right.
Thank you.
Thank you. Thank you. Take care. All right, Ms. Steinhaus, turning to you. Is there an announcement from your client?
I was wondering, Your Honor, if it would be okay if I could go into a breakout room with Attorney Walker and just review the actual offer so I get a better understanding.
I have no objection to that. Could Mr. Walker, Ms. Steinhaus be placed in a breakout? Do you want your client in there as well, Ms. Steinhaus, or no?
No, not at this time. Thank you.
All right, so Mr. Walker and Ms. Steinhaus be placed in the breakout. Mr. Finley and Mr. Finley and Mr. Howard, in the meantime, if you could start sending me your paperwork, I'd love to sign as much as I could before I left today.
Absolutely,
Judge.
Working on that now.
Thank you so much.
Will do. Thank you.
All right, are we back?
We're back, Your Honor. The announcement is it will be a negotiated plea. If we could just have one moment, I'm gonna try to get the plea paperwork filled out as quickly as possible over the council, and we can close everything out today.
Wonderful. I'm waiting on some other paperwork too. Can I begin the plea line of questioning, Ms. Walker? I'm assuming I can do that at least.
Yeah, we can, Your Honor.
Ms. Holcomb, are you present on this Zoom conference?
Yes, ma'am.
All right. Do you understand your constitutional rights? You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney today. This particular proceeding is taking place by video. That means any member of the public can log on and watch this particular proceeding. Do you understand your rights and how I'm conducting this hearing today?
Yes, ma'am.
Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes.
Mr. Walker, put onto the record for me the state's offer at this time in its entirety.
Yes, Your Honor. To the count of, I'm sorry, let me pull up the calendar. I don't want to get this wrong. To the count of following too closely, we will merge that into the hit and run, which is count 2. The offer on that is time served, balance probated with a $1,000 fine. And to count 3, which is false report of a crime, the state will be submitting a null process in exchange to the guilty plea to count 2, which is the hit and run.
Okay. And that was your understanding, Ms. Ninehouse, of the plea offer?
Yes, Your Honor.
And do you stipulate to the factual basis, ID, and venue?
So stipulated, Your Honor.
All right, Ms. Holcomb, I'm going to continue the line of questioning. Has anyone promised you anything in exchange for taking the plea today?
No, ma'am.
And you understand that by taking the plea, you're waiving your right to go to court regarding this matter later and present any defenses you may have had to these charges?
Yes, ma'am. I understand.
And you're prepared to waive these rights today?
Yes, ma'am.
And you understand the fines that you're gonna have to pay as part of taking this plea? And you understand you'll be on probation until you pay said fees?
Yes, ma'am.
All right, as to the charges involved in this particular case, how do you plead, Ms. Holcomb?
Guilty.
I accept your guilty plea. Make sure that you keep your address and information updated with your attorney. Hopefully we'll get this plea paperwork signed in the next few minutes. And otherwise, Ms. Holcomb should be free to go, and Ms. Steinhaus, if you just remain until you can indicate that you've got it from Ms. Walker, Mr. Walker.
Yes, Your Honor. So Miranda, you're free to go.
All right. Thank you, guys.
Thank you.
All right.
Have a good day.
All right, I believe that will conclude the calendar. We'll just hold, I was trying to hold for Ms. Steinhaus to confirm receipt. But what we'll do is, we've already reviewed the calendar. Competence, did we review we reviewed the entire calendar, and I believe we don't need a DV reset. So I believe we'll be in recess until next Tuesday, which is July the 5th at 2022, at which time Judge Morrow will be presiding. Please send all paperwork to Ms. Bill Brooks. I will be here for about another 20 minutes or so, maybe stretch as long as I can. But please send it so that I can sign, and that will conclude the calendar. Take care, everyone. Have a great rest of your afternoon. Bye-bye.
Thank you, Your Honor.
Thank you.
Bye.